May I have minutes kindly to mention a matter for drawing up and completion. Order passed on the 8th of November 2024. Thereafter, my lord, a review was preferred. So we had done this exercise on the previous occasion that went through, my lord. We would require another copy of it.
Review is still pending.
No, my lord has disposed of it.
So it's
Extremely obliged.
Lordship, may I have your lordship kind leave to mention, my lord, part had company matters, my lord, your lordship had made it returnable on 14 November.
Yes, please hand over.
Has not come, my lord.
Oh, it should have. Yeah.
Lordship.
This to the
Thank you.
official
Yes.
Lordship, I am mentioning.
Appellate side. Company matter
Original-
also?
Company matter
Appellate
original.
Tribunal. Yes.
Lordship, I am mentioning item number 15. The petitioner seeks to withdraw this writ petition.
15.
Yes, Your Lordship.
Well, in this matter, I am for the answering respondent. I've got the
So both
notice
sides
of
are present. Where will pass an order right now? We'll
Your
take up out of
Your
time.
Lordship may keep the instructions on record.
Yes. At order. Item 15. The matter is taken out of turn on being mentioned by learned counsel for the petitioner. Learned counsel, on instruction, submits that the petitioner seeks to withdraw the present challenge. Accordingly, WPO 1317 of 2023 is dismissed as withdrawn without any order as to cost. The written instructions in that regard, filed by learned counsel for the petitioners, be kept on record. Thank you. Please give your names, both of you. Yes.
Number 1. Your Lordship, I appear on behalf of the continuance. Your Lordship, may I have the leave to appear virtually?
Yes, absolutely.
Lordship, I appear for the petitioner.
Your Lordship, this is that electro-steel matter, Your Lordship.
Yes.
We are trying to get the matter heard. It's the item number 22 today before the Honorable Chief Justice bench.
Oh, achha.
It is that matter. Mr. Ali is there.
Yes.
So today also it's appearing quite high up in the list, my lord.
Right.
It
So we'll
may-
keep it Friday week then? Next
Friday week, my
holiday?
lord.
Grateful, Your Lordship.
Right. Learned counsel for the part, learned advocate general.
Yes, I am led by the advocate general.
The learned
Doesn't know
advocate.
that your lordship has a peripheral view.
I have a direct view. He has a view. The learned advocate general submits that the appeal preferred against the parent order is fixed for hearing today before the division bench, taking up such appeal. Accordingly, for the sake of propriety, let the contempt applications and adjourn till April 25, 2025, when it will be listed under the same heading. Thanks.
I'm grateful.
I'm grateful.
Thank you.
Grateful, Your Lordship.
Number 2.
Two will take up after the main matter. 2 is the review. Yes, pass. Not today.
Number 3.
So, Bachat, I'll request you to conclude today because we cannot reach the other matters due to this global.
It will be impossible. But I
Okay,
tell you
broad
what,
contours and written notes of arguments. You can if you want. Very well, if you can. No pressure, if you can.
no, my lord. I'm just trying to think about how we can go about it.
No, very well, if you argue in your own way, Mr. Bachat.
No, my lord. I'll tell you, lordship. I'll tell you, lordship, what I'll do.
There are so many
Since your
facets
lordship
of the matter. We understand. I appreciate that.
No, absolutely, my lord. Just thinking. Just give me 30 seconds, my lord.
Please. I mean, you can arrange.
And I'll see how I can cut
Thank you
it
very
down.
much for that.
Then we'll get someone else to respond to that. Okay, so that part we can cut out. Detailed submission. Award, we can give a note. Okay. But could I just indicate then how I can shorten it even further? But I've tried to go via these notes to shorten it.
Yes. Note
I've
will be
tried
there.
to do that. Now, what I can do, Lord, is this.
Yes.
I can take about, Lord, your Lordship will give me about 45 minutes on facts today.
Please,
On
whatever.
facts today. And, Lord, on the award, I have 3-4 different types of notes. I'll see which one I can give your Lordship. So, my Lord, the award.
I'll not take the notes today. You can modify
Yes,
those.
yes. So therefore, my Lord, so on the award, I'll give a note. I'll just give your Lordship, Lord, briefly what is there.
Yes.
So
Thank you so
that
much.
will not cut down by a large amount.
Yes,
Lord, on the law, I can't say I'm fully prepared to place it today. I'll tell your Lordship why. We were thinking that today will take time
Obviously,
on the other things.
on the fact.
So if your Lordship will give me maybe an hour and a half today, and then take up other matters.
Absolutely.
On the next day, I can come and do the law. I'll take the least amount of time possible.
Thank you very much, Mr. Bachchan. That would be fine for us.
Otherwise, I would have needed one more half
No, because
session.
I did not give you. Did not tell you in advance this.
No, that's all right. Not that's all right.
Because there's too much pressure of these.
No, I
matters.
understand. I understood
You know
that
everything,
from the
all of you
beginning.
know.
I understood from the beginning that that's why this would be a problem, which is why I requested your lordship. If your
Yes.
lordship can take it for one whole day on any day, then instead of it taking 4 half days, it usually takes one
Difficulty is
full
the
day.
appellate side matters, and mostly Fridays are 3:30 days.
I know, Lord.
Although I sit beyond 3:30, but even then,
Lord, I was indicating.
today I don't have any control because of the full court reference of Justice Banerjee.
No, Lord, I am telling you, lordship. But the fault is also often ours. When there's a full one day, we tend to finish it quicker than not in half days.
It's Murphy's law or something. Whatever time you have, it expands. The gas expands to fill up the speed.
Absolutely.
So, whatever time you can do it, all of you can do it, Mr. Bachchan, but up to a limit, obviously.
No, Lord, your lordship will give me 1.5 hours
Whatever
today,
you take. Yes.
Lord, and then not take up other matters
Thank
so
you
that
very
not your Lord, others are not inconvenienced in that case.
Yes.
So your lordship will have some time for the other matters.
Yes. At least we can touch them and see what they are on.
Lord, in that case, not I'll just indicate to your lordship not the
Yes,
outline first, not so I take lesser time on what I intend to do to them, Lord. Lord, I was taking your lordship not through the reports, but my summary of the reports. So, Lord, I'll just place the summary of the last report very quickly and take your lordship to that report because it's important. Now, I'm just indicating that is the report which was not there before the arbitrator. The other 3 reports were. This is the last report. This was not before the arbitrator. So I'll show your lordship, or I can just give your lordship the para numbers of the award to show that the contents of those awards were all before the arbitrator.
Mr. Bachchan, can we look into that report because it was not before the arbitrator?
Yes. No difficulty
This is
there.
not a regular appeal, and it is not an appeal at all. Section 40.
No, it's a 48.
48, yes.
And
But
Lord, in
can we look
fraud,
into
I
the
have
documents?
I've come with the judgments which say, almost identical facts.
Yes.
Where, my lord,
We can look
criminal
beyond.
complaint lodged before, during the pendency, criminal complaint lodged before, pendency of proceedings, award comes and thereafter, it fructifies in, the court looks at it. After that,
Cite at least one judgment on that point.
I will not. I have that, otherwise I wouldn't have dared to not.
No, I know that, Mr. Bachchan. Yes. Yes, please.
So, what I'm saying is, in any case, the findings and the data on which any of these reports are, the last report is based, is already there in the earlier reports. So, that was there. The second thing which I have to show your lordship is the arbitrators were aware of it. That I'll show your lordship from the paras of the award itself, that they were aware of all of this. These issues were brought up. They asked the other side to respond. The other side responded. So this part taken care of. And the arbitrators did not deal with the matter in any proper way other than to say that they are not properly presented. I'll take your lordship into that. Now, in this background, Lord, just to make it clearer, because this question will arise. Look, if you are not going to give evidence by way of sworn statements, how does the arbitral tribunal come to a finding of fraud? You keep saying fraud, it may be before them, but if not properly presented, which is what they said, look, there are no fraud requires a high level of proof, there are no sworn statements, etc. It has not been properly given. In any case, other side was not given this, that, and the other. We also did not have it. We will not look into the boxes. Your lordship will remember on the last day. And we responded showing that everything had been given to them and the other side, and to the arbitral tribunal. Since they could not open it because of some virus scanning data they have, we have also now sent physical copies.
Yes.
To which there is no denial of that. So, therefore, all of this was there before the arbitral tribunal. Now they ignored it, saying it's not been properly proved. Let's put it this way, properly presented. Now, to that, my answer is simple, one-line answer. We were taking fraud as a jurisdictional point. I am not seeking a finding on fraud by the arbitral tribunal. I am raising it by way of Order 7, Rule 11 or the like, Section 16. I am not saying you come to a finding of proof and give me money. I am raising it as a jurisdictional issue, criminal actions. which are in the session of criminal courts, because that you don't have jurisdiction. And I've taken it from the beginning right up to the end. It's a jurisdictional point that I'm raising. I was never required to prove any fraud. My simple point is, this is an issue pending before criminal court. It's a serious issue of fraud. Indian courts have taken cognizance of it. Therefore, you can't go into the issue. This is the point. Now, I did not need to prove anything at all. I only need to raise, my lord, like in a section 16 or in a order 7 rule 11, look, there are these criminal proceedings, tick off the box. Point 1, courts have taken cognizance. Courts are going into it. Another court, the civil court, has said that there are serious issues of fraud. I find prima facie.
So you try to point out fraud is involved, not to prove the
Correct.
fraud, act of fraud to the hilt.
Correct. I am not required to do so.
Right. Very well.
It's a jurisdictional point. So, my lord, this is how I get rid of this point. Now, my lord, if your lordship is with me on this, then I won't need to take your lordship through 300 correspondence. But this was the point. And I'll show it from the award instead of taking your lordship too much in detail into the correspondence in that case. Those correspondence are referred to in the award. I may show your lordship a few paragraphs to take care of it. Which is why I'm not, I think we can shorten it substantially if we proceed in this way. That's what I intend to do. So, I'm not to start off with, in that case, I'll just show your lordship one line because it's too well known a proposition. I'll go into it in detail when I do the law. 1 or 2 lines from the 2 judgments to show your lordship that Indian courts, not Supreme Court, has held. Copy gulo ache to ekhon, because we are not supposed to do it today. Ache to. No. Now, your lordship is well aware of it. But there are certain kinds of proceedings which are ousted from private tribunals.
Yes.
The Supreme Court is clear on them. And criminal fraud is one of them. So, I'll just show your lordship one line and then proceed with this line.
It has to have an element of an offense against the state.
My lord, I'm sorry.
It has to have an element of an offense against the state.
Need not.
Need not.
Need
But-
not.
Very well.
But I'll tell your lordship, the way in which it proceeds is, there may be other interests involved is one. Number 2, because it is a breach of criminal laws, only the state can adjudicate it, or a public forum as opposed to a private forum.
Yes.
It can't be a private forum. To give a very bad example, I beat him up. Now, a private arbitrator can't decide whether it's a penal offense and punish him.
Yes, that is what I meant actually.
Oh,
I
I see,
I could not frame it correctly.
Oh,
actually.
no,
The
my
offense
fault.
against, maybe the offense is, the physical act of the offense is against a person, but the state is the guardian and
Correct,
state
correct.
punishes.
Correct. That's
Offense
the
against the
point.
state in that sense.
That's the point. That's the point. That's the point. The copy then. Given.
Given.
Oh, you.
Buzalan ache.
Buzalan, your lordship is familiar with it. Please
Even
come
then.
straight away to para 35.
I'm sorry, you are for respondent number.
Para
I just-
33.
You are for
2.
2.
Okay. But please come to para 20. Constable. Para 20.
Yes, correct.
Now, all these questions are somehow vaguely involved in our matter, but please come to 4 because I'm not now coming to this. These are the questions framed for consideration. If your lordship sees item 4, whether the subject matter is arbitrable, that is capable of being adjudicated by a private forum, arbitral tribunal, and whether the High Court ought to have referred the parties to arbitration under Section 8. So it says even the civil court can't, not in certain instances. And if your lordship would come straight away to para 33. Which would be at page 545.
Yes, I found it.
Question 4, your lordship has seen, starts in the para just above that. The heading is there.
Yes.
But where the issue of arbitrability arises in the context of an application under Section 8 of the Act in a pending suit, all aspects of arbitrability will have to be decided by the court seized of the suit and cannot be left to the decision of the arbitrator. So, let me pause here for a second. Please bear in mind, we are not even before arbitrator. They are considering the question of civil court. Even the civil court can't decide certain kinds of disputes is what is decided, let alone a private forum, not like an arbitrator. even if there is an arbitration agreement between the parties and even if the dispute is covered by the arbitration agreement, the court where the civil suit is pending will refuse an application under Section 8 to refer the parties to arbitration if the subject matter of the suit is capable of adjudication only by a public forum, or the relief claim can only be granted by a special court or tribunal. Then, my lord, 34, arbitrability, I won't, my lord, I'm just rushing your lordship through. Please come to para 35 and 36. Arbitral tribunals are private fora chosen voluntarily by the parties to the dispute to adjudicate their disputes in place of courts and forums. Tribunals which are public fora constituted under the laws of the country. Every civil or commercial dispute, either contractual or non-contractual, which can be decided by a court, is in principle capable of being adjudicated and resolved by arbitration unless the jurisdiction of the arbitral tribunal is excluded either expressly or by necessary implication. Then, my lord, adjudication of certain categories of proceedings are reserved by the legislature exclusively for public fora as a matter of public policy. So, my lord, public policy is involved, which is a ground, my lord, both under 34 and 48. Certain other categories of cases, though not expressly reserved for adjudication by public fora, courts and tribunals may, by necessary implication, stand excluded from the purview of private fora. Consequently, where the clause dispute is inarbitrable, the court where suit is pending will refuse to refer the parties to arbitration under Section 8, even if the parties might have agreed upon arbitration as a forum of settlement of such disputes. The well-recognized examples, my lord, please mark this, well-recognized examples of non-arbitrable disputes are disputes relating to rights and liabilities which give rise to or arise out of criminal offences. So, my lord, well-recognized exception can't be arbitrable. I won't trouble your lordship with the rest of the judgment. It may be necessary on other points later, but I'm not troubling your lordship with it. Now, your lordship may have one possible question with regard to this. This is in the context of the domestic arbitral part, not in the context of Section 48. I'll show your lordship. Language is identical. I'll show that.
Language is like Section 34. Like the grounds of Section 34 are virtually incorporated in 40.
Correct. So it won't make any difference. And there too, I'll not draw a comparison if required. I'll not just show your lordship make a comparative chart with red or.
But Mr. Bacha, 34 and 48 come after the award is passed. So, but you are on the jurisdiction of the tribunal itself.
Yes, yes.
But if the domestic law is made applicable by.
I'm coming after the award has come. I'm challenging it on the ground that I took a jurisdictional point from day one.
You say that the arbitral tribunal could not adjudicate it because it fell within this category.
Correct, correct.
So that arbitration was an international arbitration. So you have to consider whether the domestic principles apply. But yes, the parties chose in your case to apply the domestic law.
Yes,
although
domestic law applied, not just that. We'll go into it. Sorry, what is it? That's right. Not even under 48, as Mr. The junior points out. Not under 48(2), enforcement of an arbitral award may be refused if the court finds that the subject matter of the difference is not capable of settlement by arbitration under the laws of India.
That is absolute.
Under the laws of India.
That takes care of it. Yes.
So, there's no difference, but I'll go into that law later.
Yes.
I'm just giving your lordship the outline.
Yes.
So, I took a jurisdictional point. And, I've been chasing it from beginning to end, saying, look, please decide, you're not deciding. And I keep giving more and more proof of the criminal nature by way of reports, by way of judgments, by way of opinions from legal, let's say, experts and people who are luminaries in the field. I give it to them. They do not decide, they keep going through. Ultimately, they lose their term. They become functus officio. I keep telling them, look, you are functus officio, but if you intend to proceed, please decide this jurisdictional point, including criminal fraud. Not decided till the very end. And then thrown out. On the ground that, look, it is not properly presented. They lost sight of the fact that this was a jurisdictional issue akin to Section 16. And your lordship knows under 16, if an arbitrator rejects the challenge, it is a ground for challenging the award. So, But this is the long and short of the matter. I just need to show your lordship, prima facie, I have raised very serious allegations of fraud. It is not, court has taken cognizance of it. It does so after application of mind, and letters rogatory were also issued. Because please remember, this is a foreign company outside, also gone into bankruptcy. So, my lord, the G capital 1, G capital 2, people behind them, that story your lordship will get a little later. Those people can't really be found. They are sitting
A
behind.
challenge against the award is also pending.
My lord,
A challenge against the award
that
is
is
also
over.
pending.
That is, I think one part is over. Respondent number 5, his part was taken out.
All right.
It was said that he won't be allowed.
Yes, yes.
With us, not present status, I'll just find out from
Very
lordship.
well.
I believe our challenge had failed, but that is up in challenge. This is what I understand, but I'll find that out. So, my lord, this is really the structure of the
Very well.
not argument which I'll make very briefly today, but I'll need to show your lordship. Not 3 things. One is we were on that Nangia report, not my summary of it. I'll take your lordship very quickly through the summary, but the last parts I'll show your lordship from the report, because I may not be able to put it as well as they have done it. Read with that, not I'll show your lordship one letter which summarizes and puts the dispute in a manner in which I probably not will take a long time to explain. So one letter I'll show your lordship, and then not the portions of the award to show not what was the argument made by us, how they deal with it. Not your lordship will remember up to para 120 of the award I showed your lordship. Not that clearly takes care of not all the objections that the tribunal was having to the fact initially said, look, you can't give documents like this without leave. So not, I then said, and they also said, you have not sent copies to the other side. It can't be unilateral. It's against basic principles. So I wrote saying, look, I had sent it to the tribunal earlier by way of an email. I had also sent it to the other side via email with attachments. They never protested that they could not open it. It is because of some software that they have that they could not open it. And they never told us this also. So in any case, because you said that these are not properly sent,
Hard copies.
I'm now sending you hard copies. I'm also sending them hard copies. So that took care of that aspect completely. Not the first 3 reports, therefore, were there.
Yes.
Or rather, first 2, my fault. First 2 reports were there, the third came just after that. So, this is it. Now, my lord, if your lordship would kindly take that, the summary of the report. And I think I was placing from, my lord, if your lordship comes to, Lord, from your markings, your lordship will perhaps know whether, Lord, I had come to, Lord, I had done forensic report of Nangia, which is item number 4 at page 2. I had started off on that, if your lordship has that note. But we may not have had time to start on the 4th one. I may have summarized it orally. I'm not very sure.
Yes, you did.
So, Lord, 4 A, B, C were possibly, Lord, covered. Possibly.
No, not exactly.
No.
Not exactly. No.
So, Lord, I'll just read the headings too.
You had just given the outline.
Yes. Lord, what I'll do is, Lord, instead of reading this also, Lord,
Yes, because
these
you
are
have
there.
given, yes, the page
Just see
numbers
the
have been
headings.
given here. Yes, exactly.
Just see the headings, Lord.
Right.
Please come to page item 4, Lord,
Yes.
at page 2.
Hmm.
So, Lord, the report is divided into various heads. If your lordship could just keep the report, because I'll rely on some parts of it, though. This one.
Where is that? The
Lord,
report?
the Nangia report is at page 443, also indicated in this note. Convenience compilation? No. Sorry, section 48, volume.
Section 48 application.
Volume, page 443, volume 3.
443
volume
volume
3.
দেখে নাও second হবে third
But also keep the second volume, it may be useful.
second টাও দিয়ে রাখো
But I'm not immediately referring to it. Oh. I'm not immediately referring to it. Your lordship will just take the summary first.
Yes.
that report is divided into different sections. So, my lord, the first heading, which is of importance, is anomalies in the terms and conditions for executing SPA. Lord, these are non-disclosures. Your lordship can skip this. Not really concerned. Please come to the conclusion. So, my lord, what had happened was they showed us that money was available from two investors. It turned out that those documents were not disclosed before the stock exchange, although it is mandatory to do so. So, my lord, these auditors or my lord, these forensic investigators or reports say that there is a very high possibility that they did not exist at all. So, these funds were never available. So, my lord, that is the conclusion. If your lordship sees at page 3, non-disclosure of both SSF and LOI, these are, my lord, agreements with two parties suggest they may not have actually existed and were merely paper transactions to defraud local and its shareholders. It may also be construed that JIC Capital 2 and Uphealth had misled the factual position of availability of a large amount of funds, $500 million, to local and its shareholders. So this is the conclusion. Then, my lord, anomalies with regard to pipe investment. Sorry. But this availability of funds, my lord, your lordship will remember that they will have minimum value of 1,100 million, 1.1 billion. So this is half of that is kind of non-existent, it turns out. Now, my lord, anomalies with regard to pipe investment, my lord, it's there before your lordship. I'll skip this to save some time. Your lordship can skip this. Discrepancies in the SPA. Now, my lord, here, my lord, if your lordship not sees, my lord, A, Uphealth had showed availability of funds of 174 million in the trust fund to mislead local to invest and bind them with the SPA. This was not part of the funds available to Uphealth, and the same was a contingent liability being redeemable by a stakeholder at any time before closing of the acquisition. So I explained this to you, to your lordship,
Yes,
yes. Because without going into the detail, Lord, this is money which has come in from investors. But it is dependent on this that if it fails, the money will go back. If this not the term used is consummation. If the agreement is not consummated, it will go back. So this was not really money available. It was held in trust actually for refund. It could not have been used for any other purpose. Sorry. Not, your lordship will remember I showed a chart in the beginning. There was a SPAC, a special purpose acquisition company. So, my lord, this was funds to be held in trust to ensure refund if it did not go through.
Yes, you have also said here contingent liability redeemable by the state.
Then, my lord, please see forward purchase
But
agreement.
you explain the concept.
This is important. Lord.
Yes,
this was important. My lord, if your lordship reads it, it will be quicker.
Yes.
But again, put in two lines, it's this. There was a consummation date. If within the consummation date, there were not enough funds available, all the investors would have to be returned their money. Now, in this case, this CAF wanted to go out. If CAF had gone out before that consummation date, that would have been the end of the deal. They would have made no money. Not JIC Capital 2 would have made no money. So what they did is, consummation date is tomorrow. They enter into an agreement with CAF saying, I will give you this money day after tomorrow with interest at a fixed price. So it's a forward purchase agreement, but really speaking, the man had wanted to go out by keeping in for not a few extra days. The deal did not fail. So these are not known, and because they were paid 2 days later, they could not pay us not the value of the shares which was due to us. So this is not what this was. Then, my lord, valuation of UPHI, my lord, this I have not showed your lordship quite a few times, my lord, how the valuation was not there. Now, my lord, this self-enrichment. Now, this becomes important. From here, my lord, if I may just take your lordship, not once into the Nangia report, my lord, if your lordship would come to page 491.
Volume 4 tell
He's also got to get. But the report starts at 443. I'll not have managed to save your lordship the labor of reading 50 pages perhaps.
Thank you.
Although, my lord, it makes for interesting reading otherwise. And not they also refer to the criminal proceedings pending
Yes.
FIRs. I am not going into that for the time being. Now, this is the more interesting part of the transaction, perhaps. Yeah, I know. But self-enrichment.
Yes.
The memorandum of opinion of 1st March in the Court of Chancery. So, this is relating to a judgment passed in one of their matters. Chancery, Delaware State, between Cody Laidlaw and JIC Acquisitions 2, where the plaintiff on behalf of himself and stockholders of JIC Capital 2 filed a verified class action complaint asserting breach of fiduciary duty stemming from JIC Capital 2 merger with Uphealth and Cloudbreak. So, the class action brought. Sorry. Cody Laidlaw filed the complaint before the Honorable Court on 23rd September 21, against which the defendant requested on 3rd November 21 to dismiss the complaint, and briefing got completed on 20th May. Honorable Court heard oral arguments on the motion to dismiss. Not then that motion to dismiss was not plaintiff contends that the defendants were motivated to undertake value destructive mergers at the expense of public stockholders who would have been better served by redeeming their shares. The sponsor, JIC Acquisitions 2, would be left empty-handed if JIC Capital 2 did not merge. But that's this company. JIC Capital 2 is not Uphealth. It got renamed as Uphealth. Uphealth Incorporated. Uphealth Inc. We'll go there. Now, I'll hand up this judgment. The sponsor would be left empty-handed if JIC Capital 2 did not merge, since the founder shares and private placement units would be worthless. It's pertinent to note that the sponsor, JIC Acquisitions 2, and directors Avi Katz and Raluca Dinu will lose their entire investment in JIC Capital 2 if an initial business combination, JIC Capital 2 with UPHI and Cloudbreak, as of 20th November, is not consummated. But this is what I was explaining. Prior to JIC Capital 2's initial public offering, founders collectively with JIC Capital 2 and underwriters, JIC Capital Northland, JIC Capital 2 Investment and Earlybird, purchased an aggregate of 43 lakh or 4.3 million shares for an aggregate price of $25,000 or approximately 0.0058 per share. And what they are telling us, it's worth 10 minimum. As compared to $10 per share price being used to determine the number of shares of common stock being issued to Uphealth and Cloudbreak equity shareholders, not which is us, where founders acquired 40 lakh shares, 1,73,011, so and so, respectively. Hence, against an investment of just 25,000, the founders were holding shares valued more than $37 million. The Honorable Court hence came to the conclusion that the defendant did withhold material information about financing terms that harnessed public stockholders as presented by plaintiffs, thereby denying the request for dismissal by the defendants, and had considered the fiduciary duty and unjust enrichment claim reasonably conceivable. Not that the court comes to a finding that there is a breach of fiduciary duty, but they had asked for dismissal on the ground that it should be dismissed on the ground that demurrable. Court said no, these charges are credible. Petition being filed by the stockholder, like our Section 16 case.
Yes.
Petition had been filed by the stockholder, Richard Delman, against the related company of JIC Capital 2, that is JIC Acquisitions 3, LLC, bearing case number so-and-so in the Court of Chancery, State of Delaware, where also stockholder of JIC Acquisition 3 SPAC complained against the same founder, Avi Katz, for breach of fiduciary duty, and Avi Katz moved to dismiss the complaint on 31st August, where the brief got completed on 1st March, and the Honorable Court heard oral arguments on the motion to dismiss on 23rd September and concluded that the standard of review is entire fairness, with the defendants bearing the burden of persuasion at trial. So goes to trial.
MRR was refused, and
That's it. Right. So, then, the next para is they've been paying large amounts to the key managerial personnel, and the charts, if your lordship goes to the next page, 493, please see the amounts being paid to these people. Basic salary, bonus. And the total compensation, your lordship will see, Dr. Balakrishnan is getting $2.2 million, and not all of them. And then if your lordship comes to the, sorry, it's $22 million. I'm sorry.
22, yes, yes.
$22 million. And not all of them are getting huge. Look at the number of people involved. Similarly, please see the second lot.
Yes.
Then, share prices of the following companies affiliated with JIG Capital in past and present have experienced significant declines over a specific period. So now they are pointing out there's a pattern. So, there was a JIG Capital 1, which became Calera Investment Incorporated. Share prices declined from $65 in February 21 to US dollar 1.65 on 31st March. Subsequently, Calera was sold to Tata Communications, which itself is now in a bad way. Then
Now we know why Tata Communications is.
So then JIG Capital 2 is upheld. Share price declined from 102 US dollar 102. Was that right? No, that's not right though. Oh, this JIG Capital. Share price declined from 102 on 1st June to US dollar 0.24 on 2nd January 24.
Sort of bungee jump.
Absolute.
Yes.
And not in a
But bungee come up.
It comes up at least not 3/4 of the way.
Right.
Subsequently filed for bankruptcy. Now this is important. Then JIG Capital 3. Lightning E-Motors. Share price declined from $16 to $1 on 20th November. Subsequently, on 7th February, Lightning E-Motors is to liquidate all of its assets. So liquidation there. Then JIG Capital 4, which was Big Bear Holdings. Share price declined from $12 to US dollar 2 on 2nd March. Then JIG Capital 5. Share price declined from 11 to 1 in 1 month. Then, based on the facts mentioned above, it is important to highlight that Mr. Avi Katz, founder of JIG, has a history in deceiving stakeholders and other shareholders of the respective SPACs. His strategy involves inflating the company's value to attract public funds during IPO, while insiders invest at a lower rate. They then charging exorbitant transaction costs and paying higher remuneration to key managerial personnel from public money while restricting shareholders to trading them. So this is the catch I can't get out. This is a zero-sum game. If 10 shareholders win, the amount of their win must be offset by the loss of the others. You prevent me from getting out, you make the game. Subsequently issuing themselves high number of shares of the company at a low price. Here your lordship has seen $0.0058 is what they bought it for. And they tell me it's worth 10. Eventually, they describe the market value of the shares by selling off their SPACs or liquidating their assets or filing for bankruptcies, which erodes the value for all shareholders. Then 5.2.5 is a different aspect of the matter. I've taken your lordship through that. They put up on all the public media posts that I have been appointed, will be there, and then ultimately turns out I'm not appointed.
This has been perfected in India from long back. This modus operandi.
That one.
Yes,
in a different way.
They are now in a different way.
Completely different way. Those were not cases of promoters initially doing it, from what I have understood, because I've done a few stock exchange matters.
Obviously, you know much better.
No, I don't. I've done the stock, not during the crash of the Calcutta stock exchange. And, I did a lot of matters. And from what I've understood, the way it worked in those days was there's any share, it did not matter what. So it could work in two ways. Either the promoter of the company says, he talks to a bunch of brokers and they say, look, let's take up the price from 50 rupees to 200. So they will not resort to circular transactions. So the broker will buy one share, he will sell it to another broker who will buy it, and the share price keeps going up on a circuit till it is up.
It's a perverted capital formation sort of principle.
The fun bit here is this. It makes so much sense in economics. It's like this. Let's say I'm the promoter. So I know I'm going to play this game. So I tell my friend, let's say Mr. Chadda, look, this is going to go up, you buy it. So I've bought 100 shares, let's say at 100 rupees. That will push up the price to 110, let's say. Now he comes in second, he buys it at 110. Now when he buys it at 110, it pushes the price up. Now he tells 4 of his friends that this is going to go up. The promoter has told me. So by the time Mr. Shattuki buys it, it is 120. So it is keeping on pushing the prices up. Now, when it goes up, I am the first one to know, okay, I'm going to now no longer support the game, let me sell. So, my lord, I've got in at 100, I'm selling it at 200, I'm the first in, first out. So, maximum money made by me. So, I tell him now, look, I have gotten out, I'm about to get out, you sell. He's got in at 110, he'll sell at 190. That pushes the price down. So, my lord, ultimately, someone right down the line is held, not left holding the baby or the bath water, as they say, my lord. So, my lord, this was one way where the promoter was involved. The other was, my lord, classic cartels, my lord, your lordship has seen very big, not very big entities or persons holding, my lord, control, Harshad Mehta kind
Yes,
of
right.
thing. So that was the second. Today, my lord, the scam is this. It is not a person anymore. Earlier, it used to be a person. Now, my lord, these are big entities with huge amounts of money. They can do what Harshad Mehta did, but better because there is no accountability.
Yes.
So that's how it is, my lord. So, my lord, this is the kind of situation which has happened here. So, from self-enrichment, my lord, if your lordship comes to item 6, I won't trouble your lordship, appointment of Azim as chief officer and additional director. Not that report has all the, my lord, declaration, the stock exchange, all the evidence to show this. It's all given there. And then, my lord, if your lordship would come to 501, here, my lord, I want to trouble your lordship a little.
Yes, 50.
Page 501. Lord, should be a heading called modus operandi.
Yes.
Appel orchestrated a complex and elaborate transaction to defraud local shareholders. Their transactions and schemes aimed to induce and deceive local, particularly in relation to a significant transaction, i.e., share purchase agreement and with Appel Think. Following are the key elements. Then, my lord, G Capital 2's initial public offering, founders collectively so and so, purchase, my lord, your lordship has already seen that at, my lord, 0.0058 per share. That's the first thing. Then, my lord, your lordship sees that there were business combination agreements, which I've told your lordship about. They enter into agreements with us. Then, my lord, SPAC shenanigans. Upheld principle set up a SPAC. Shareholders could redeem their shares while approving the business combination agreement. Importantly, this SPAC arrangement violated the warranties in the SPA. Intent to deceive. Upheld induced local by entering the SPA with Appel. They did so by presenting padded financial records and false SEC communication filings. SPA was based on these misrepresented financials. No basis available for valuation of $536 million. Not detail I've given your lordship from the earlier reports. I won't trouble your lordship. Then G Capital was not operational, and this is important. G Capital 2 was not operational and had recorded zero revenue from operation in the financial year 31st December. In contradiction to the same, G Capital 2 considered valuation of 536 million of UPHI as on 31st December. Form 10Q for the quarterly period ended 30th September, filed by UPI, mentioned that UPI has no revenue for the period of 30th September.
You did not check any of these things. Did
Not-
you have any means to check? I mean, it is aren't these public records?
Your lordship will remember, there's a few things happening. Let's say, I'm entering into a
You won't look at the credentials. I mean,
No,
what
we
is-
have not credentials. Who is behind? Not your lordship has seen. So there is a G Capital 2.
Yes.
Behind that is not another company called GIC Acquisitions. Behind that is one more company, and behind them are the promoters. Not very difficult to
several
find.
layers.
And not numbers of agreements to which not we are not party, because it is all dependent on 5 sets of companies not coming together.
There's something called masking in internet operations. It's something like that.
It's something like that. Not, I'll show that this also says that, not artificial facade built by them.
Yes, exactly. That is exactly IP masking.
Correct. Not it's like that. Not IP, I believe, can't be masked. I don't know. Can
It
it?
can be. Yes. Oh, yeah.
Oh, I thought not every device has a unique IP address, which
Yes, you can replicate. Yeah,
I don't.
right. Not even a facade.
But it seems that I have good hackers around the place saying that sitting here, they can do it.
Ethical hackers.
But ethical or unethical, I don't know.
Right. The hackers are the brilliant people. They're the most brilliant.
And I had a nephew, not in class 6. He came for a holiday for not 15 days to Calcutta. His mother was away and not much to do. So he was fiddling around all day on my computer. So I asked him, what are you doing? So he said, I'm learning to hack. So I said, does your mother know this? He was, of course, he
He'll
became
know when he starts blackmailing you.
No, he's too old now. He's not, this is years ago, and he's one of those whiz kids. He's a real whiz kid. Never actually studied what he was meant to study, but he would be always.
They are the ones.
concentrating
They are the
on-
brilliant
correct,
ones.
Correct.
They
Very
don't
bright.
go inside the box at any point. They are always outside the box.
Absolutely.
There's no box for them.
But he's at some front, not cutting edge,
Must
not
be.
technology somewhere. So
Must be.
now, my lord, if your lordship comes to 502, Upheld Inc., previously known as G Capital 2, had presented the trust fund of $174 million, which is a contingent liability, which
Yes,
is what
yes.
showed your lordship. Since the same will be redeemed in a future basis, completion of the SP and amount can be withdrawn by the stakeholder before closure of
So
acquisition.
there are certain overlaps in the heads.
Yes, there.
Has to be.
This is the conclusion, my lord,
This
really.
is the modus operandi, so the entire thing
Yes.
comes. Yes.
So, my lord, here the story is put together. So,
Yes.
my lord, I'll just read it. It'll make life easier. Amount can be withdrawn by the stakeholder before closure of acquisition, hence stating $174 million misled GHSPL to invest and bind with the SP. In addition to the same,
This bullet
non-disclosure-
point is extremely good.
Yes,
I find.
this is very good.
This whoever has done this, I mean, I don't know if one of the hackers has done it, but it's extremely good.
This is that not a Nangia report.
No, this bullet point, your
This
note.
bullet point. But we worked on this together. my lord.
Obviously.
We all worked on it together. And there were some portions I couldn't understand at all. But there's too technical. So there, that's why I said this portion of the report, till before this, I would say, I mean, this report, the first few parts were easy to do. The later parts became very difficult because they were very long and very detailed. But then it wouldn't have been a summary, which is why your lordship will find
Right.
that these have become longer. Right. So, my lord, in addition to the same, non-disclosure of the LOIs with GEM and Cloudbreak to the SEC suggests that both LOIs may not have actually existed and were merely executed on paper. Then, my lord, share value declined. Then, my lord, see the next one, artificial facade. Warranties in the SPA were essentially a facade. Upheld injected borrowed money or promised term sheets into companies like Upheld Holdings Inc. to inflate their financials. This maneuver aimed to mislead shareholders and the public into believing these companies had substantial funds. Then, Lord G Capital 2, in spite of adhering the obligations as per SPA, advertently transferred funds to third party without prior intimation and confirmation with GHSPL. Additionally, Upheld unable to disclose the fact of entering into an agreement with CAF at the time of private placement offer.
Is it in spite of adhering or instead of? I mean, Capital 2, in spite of adhering.
No, it's in spite. But they, in other words, they paid 22 million.
So they adhered to the obligations as per the
Of paying 22 million.
Oh, right.
22 million.
Achha.
But they had no funds, and thereafter they transferred it out without telling us. Then additionally, Upheld unable to disclose the fact of entering into the agreement with CAF at the time of private placement offer from Glocal on 17th August, also when the final call was due on 15th August. That's when he was to pay not to the Indian company for the shares. G Capital 2 transferred the previously held 18.1 million in cash from escrow to CAF along with $0.4 million of interest instead of Glocal. Then target companies were left hollow. Upheld misled target companies by inducing them to surrender their shares with promises of funding that were never fulfilled. As a result, acquired companies were left underfunded, causing their stock values to plummet. According to Exhibit 99.1.
What are these target companies? Target
companies
in the sense?
For example, there were five companies. There were 5 companies.
Get it.
And each of them, same situation.
Right.
According to Exhibit, according to Exhibit 99.1 of Upheld's Form 8K filed on 21st March, Traces and Behavioral Sciences, 2 more of the target companies like us, 2 companies acquired by JIC Health filed for bankruptcy on 20th October 2023, leading to cessation of their operations. So, it's everyone who suffered, not just, I was not the only victim, not American companies and other global companies also. This contradicts the revenue projections made by McKinsey in their report of 15 February, which your lordship remembers, damages we've seen, which forecast Thrassy's revenue for the fiscal year to be $131 million and 226 million. So, instead of that, forecasted 131 million and 226, these companies went bust. And behavioral sciences revenue to be between 17 and 22 million. The discrepancy suggests that neither the McKinsey report painted an overly optimistic picture of future projections for Thrasy and BHS, or these companies lack the necessary funds or capabilities. Then, in summary, Uphell's actions allegedly harmed both local and unsuspecting shareholders, all the while benefiting themselves by exchanging worthless shares for valuable ones. Some specific warranties held out by Uphell to shareholders in SPA were shares, would be worth no less than 110 million. Your lordship is not aware of that. I won't trouble your lordship with it. Financial commitments, etc. All of these not met. I won't trouble your lordship. Then, comes to the bottom of the page. Stock value decline. Your lordship is seeing the value, the way in which it falls. And if your lordship turns the page, eventually it fell below $1, leading to a reverse stock split.
Yes.
5
As you
joints.
said, yeah.
To comply with New York Stock Exchange requirements, share prices of the following companies affiliated with G Capital in the past have experienced significant declines over specific periods. So now, my lord, I've already read that out to your lordship. G Capital 1, Calera, I've already read that. G Capital 3 is Lightning Motors, same thing. G Capital 4, Big Bear Holdings, same thing.
That's how it has been reproduced.
Yes. G Capital 5, so, your lordship is seen methodically. This happens, then, comes to the next one. Abbey Katz, the founder of JIG, has a history of deceiving shareholders and other shareholders of SPACs. His strategy involves inflating company value to attract public funds, while insiders invest at lower rate. They then charging exorbitant transaction costs and paying higher remuneration to key managerial personnel from public money, while restricting the shareholders.
But this is a bold allegation. I mean, there's no indication of whether they were ever prosecuted under commercial.
But those two actions filed in US
No.
That's the allegation. No,
that was
prior, all prior. And this judgment was before the tribunal. This was placed 1 year before the award is passed. I'll show those to your lordship. So, this is all a matter of public record which were placed before the arbitrator. Now, while restricting shareholders to trading, subsequently issuing themselves high number of shares at a low price, eventually they destroy market value, etc. Rapid decline occurred because Uphell was essentially a shell company with no reserves. The company's books and filings were allegedly manipulated to inflate enterprise value artificially, in summary, etc. Then, my lord, the next para, this valuation, my lord, I won't trouble your lordship again. 1.1 billion, it's not, how it's wrong and how they've stripped the company. And, my lord, if your lordship sees the third white bullet point, actual enterprise value, not in the middle of that para, deceptive share value, actual enterprise value was much less. Then, my lord, G Capital 2, in connivance with Cloudbreak, misled the factual position of 25 million to local, inducing them to enter into SPA. Additionally, lockup agreement. So that came 1 year late.
Cloudbreak and UPHI are the companies with whom they had FPAs.
No. Forward purchase agreement was with a company called CAF. KAF.
Right.
Now, this lockup agreement was entered into with us later, long after the SPA, saying that, look, before I can list, you have to enter into a lockup agreement because otherwise listing will not be permissible. So I entered into that. So lockup agreement was a deliberate attempt by Uphell to bound their shareholders, including Dr. Azim, to disable them to sell off the existing shares of Uphell, resulting in a probable loss of $100 million, because 110 million was the minimum amount. UPI has neither fulfilled the terms of the SPA by giving consideration of the value of shares not less than $100 million, and for considering Dr. Azim as director, etc. And then, my lord, the summary. The lordship can also see the summary. In summary, if your lordship goes quickly through it, my lord, what it says is basically by paying 13% of the price, that 22 million part in cash, they managed to try and get control of 97% or 94% of the company. And the shares which were given were essentially worthless. And in support of everything earlier in the report and by way of annexures, they've given all the documents on which this is based, filings with the stock exchange, disclosures, the agreements, the share price movement on the New York Stock Exchange. All of that is not over here. But what I'll do to save time is I could not also at the moment show your lordship that all of this data, this report, like I said, was not before the arbitral tribunal. But all of this, the contents of this, really speaking, are there in the reports which were already there and in my letters. So I cannot give it to your lordship now, take your lordship through it.
The conclusions might not have been there.
What I can, conclusions were there. Conclusions were also there.
Oh.
This is a far more detailed and a better study.
Comprehensive sort of.
Now, what I can do is either, that same note of these charts, I can give your lordship, and for the third report, give your lordship the corresponding, where this corresponding piece is in the earlier report, I can either put that in or give your lordship a chart to do it.
Give a chart, yes. Whichever way it should.
Or I can take your lordship through it very quickly. I can do that. I'll give it by way of chart. It'll save time. Just make a note, we'll give a chart. Because we've not carried out this exercise ourselves. So,
and if you give a chart, that will a copy of that will be given to them.
Of course.
So they can also, point out if there is any fallacy.
Whatever we've given your lordship.
Yes, we know that. So they can point out.
Your lordship,
not basic.
I'm sorry to interrupt, your lordship. May we also get it on email? If that's possible, we can reduce the number of papers also.
Yes, why not? Why not?
I'm really sorry to interrupt.
No question of interruption.
You give us the email.
Yes, you're right. Absolutely right.
Yes.
You give us the email address, we'll send it.
Give the ID.
Yeah.
That'll be easier for them also.
Where was I? Yeah, from here, where do we go to Delman? Letter. Okay. So, now two things I'll show your lordship, since we are now not cutting it down. Just keep the award once. I showed it on the last day. I may just refer to it once or twice.
Yes.
And these letters are all referred to in the award. I'll show your lordship one letter, which I think will not prevent me from having to repeat anything. And the summary is nicely there. So, no, first the award. Let me show that para. Convenience compilation, volume 2B. One para from the award, I think.
Volume 2A or B? Part A or B?
2B.
That was the question. To be or not to be?
The award starts at 391, and if your lordship would take inner page 53 of the award once, or rather inner page 51, para 120 of the award. Page 441.
Yes. Yes.
Before on that page itself, your lordship will find that bold portion in bold. This is that box is being received.
Yes.
That your lordship has been through.
Yes.
Now 120. Now this is important. 15th November, respondent number 4 wrote to the tribunal on behalf of the first respondent as follows. I won't trouble your lordship with all of it. Now, I just want to show your lordship one para of it, para 8.
Yes. Para 2, 5, 6, 7, and 8, and 11, I find marked. Either you or Mr. Thakkar had.
We've shown it. I am not troubling your lordship. I'm just showing it for one very specific purpose because I had made this submission in the morning. Further, strictly without prejudice to our objections, we would like to point out that the tribunal has not ruled on the jurisdictional challenge raised by the respondent. In a nutshell, the jurisdiction of this honorable tribunal is challenged on the ground inter alia of non-arbitrability of the dispute in terms of bar under 430, the egregious fraud committed by the claimant, pending criminal investigation in India, past conduct and court rulings against the claimant showing trained to defraud and prima facie finding of Indian court that fraud has been committed against the respondent. So, my lord, again clearly raised there. Now, there are a lot of other things, but it's saying basically, look, my challenge is on the point of jurisdiction.
Only one thing, Mr. Bachar,
Yes.
the same set of facts may have criminal and civil consequences.
Yes.
So, why not the tribunal can adjudicate on the
Right.
civil things?
Right. Now, Lord, your lordship is right there. This is a point which comes up before courts.
If,
Now-
suppose there's a trespass, there's a criminal trespass proceeding, parallelly those can continue.
Absolutely. Now,
So why not?
Now, Lord, two things over here. Now, Lord, this issue has come up before, Lord, courts, and I tell your lordship frankly, now the courts have, Lord, this argument has been made. There's a difference between the civil part of it and the criminal part of it. Now, what the courts have done in relation to arbitral proceedings, as far as I could see, Lord, if I am to cull it out from the judgments,
Yes.
is this: if it is a serious degree of fraud,
Yes. That
then
is
then not out of arbitration.
right.
So your lordship has to see the seriousness of it. Now
Yes,
here,
yes.
Lord, the courts have taken cognizance. Letters rogatory were also issued, and etc.
But serious degree of fraud, hasn't that been diluted subsequently? That even serious cases of fraud where particulars are required, because arbitral tribunal can always appoint experts and all these things. Probably there are judgments that has been diluted subsequently. You will be able to know better. I want you to please consult those before they put. Yes.
Please. No, I'll be placing those judgments.
We'll obviously be placing all.
I'll be
Yes.
placing the judgments. So I'll take your lordship
Right,
to the line of it, or at least not try and say, look, on the basis of these five, this is the ultimate conclusion. This
Yes,
the
absolutely.
other side can then distinguish
expect
it.
that from you.
It'll not make it. It'll make it shorter rather than placing 10 judgments.
Unnecessarily, yes.
So I can give your lordship the list of judgments, but ultimately I'll place one or two maybe.
You can place the most important ones, sir.
Right. So now, my lord, this I was showing your lordship to show that, look, even now, not my first jurisdictional challenge is made 10, 12, almost a year and a half before.
Yes.
And I'm keeping on writing. And I'm giving them more and more details on fraud. As your lordship has seen, if your lordship goes back to that box, the contents of that box, that chart, where is it? Give me that page. That box had, please see, the Nangia report, which I've not Nangia.
Not Nangia, apart from that, the others.
Agarwal Lodha, it had the page 43, no? But please come back to para 95. I'm keeping on giving them more and more to show them that, look, there are serious questions of non-arbitrability. And, my lord, if your lordship sees page 42, para 95, the contents of the box include legal opinion. Not forget it as opinion, but not at least not the judgments are over there.
These boxes contain the contents of those boxes.
Yes. Independent report of Puri, which I've showed your lordship. Report of Agarwal Lodha. One second. Agarwal Lodha and not another learned judges. But not the nature your lordship will find from the third box. One is legal opinion stating ex facie allegations of fraud against upheld and its principles are correct and not sufficient to proceed to proceed to trial. Then
Legal opinions may not be so important, with due respect.
Yes.
2 and 3, 2 and 3 are.
Your lordship will only read that as part of my arguments, nothing more.
And 2 and 3
Because
are definitely.
Yes. Report evidencing financial misrepresentation.
So those actually comprise of the evidence, sir.
They never had the money to fulfill and breach, etc. So, these were there. And not just that, they are asked to react. So, this para 120 again, the portion I've showed your lordship, raising the jurisdictional challenge, this letter is considered and they are asked to react also. And they react. So, it's not as if the arbitral tribunal is not. Now, still they don't decide on jurisdiction after this. So, two more letters follow. Two more letters follow. And, if your lordship gives me a moment, I'll have it somewhere in my notings. Please just give me one moment. Yeah. No, before that, there's one more of September. I remember that. There's one of September. Anyway, ठीक है, छोड़ दो, doesn't matter. Now, my lord, a number of letters are going, my lord, regularly. Initially, the objection was, look, the letter is not from from a respondent, but from a shareholder. That problem goes.
Para 109, para 108,
Yes,
para 109 refers to certain something was written by the CEO of the first respondent.
Yes. So, not this is continuing all through. The point is, all through we are saying, look, you have not decided jurisdiction, and they are not deciding it. They are asking the other side to react. They take their reactions, keep it in their pocket, and still don't know. So, my lord, these letters keep going out. Now, my lord, if your lordship then, my lord, comes to, oops. One letter only, I will show your lordship, the last letter before I stop, not the correspondence. Now, my lord, if your lordship comes to page 1494, which is at volume 10 of the section 48. It starts at 1454. Yeah, I'll do that.
Yes.
So, my lord, if your lordship would come to page 1454. Lord, please see the heading, claimant's letter of 18th November, etc., and without prejudice submissions by the respondent only in the aspect of jurisdiction and perjury.
This was their response.
No, this is ours. We are again writing.
Oh,
now, 20, your lordship has seen the earlier letters. I'm just showing your lordship, I'm taking this objection from the beginning right till the end. And this is going from, again, a respondent, local. Now, my lord, please see only the preface one line there, inasmuch as the respondent is making without prejudice submissions only on the points of jurisdiction, non-arbitrability, and perjury. Present memorandum would only be pointing out facts which have been misstated, etc. Now, my lord, here, let me just show your lordship just one or two portions of this. If your lordship would first come to 1456. Last para. Respondents have not participated in the proceedings because of their bona fide understanding inter alia that under Indian law, disputes are non-arbitrable. Tribunal has been constituted prematurely. Tribunal in any case has been rendered functus officio. Please see this, not all these points. Not I've been writing for a year, now they become functus officio. They still continue. It is therefore once again requested that the tribunal first rule and decide on the preliminary issue of jurisdiction before proceeding any further. And not this is the stand all through. Now, para 2, jurisdiction of this court is challenged on the following grounds. And, my lord, if your lordship, not this premature constitution of the tribunal, I'm not dealing with this point. I believe not someone else, because your lordship had asked us to ensure that we are not duplicating areas. Not someone, not someone else, not for some other party will be.
How many else are there?
Not
how many else are there?
How many more? I don't know. 3 more.
3?
Three more. But not they will not be taking care of this part. Not the
Your
action.
lordship,
One of them
yeah.
is there. Yes.
Yeah, your lordship, I also wanted today to disturb like this good arguments by saying that we need to at some point of time also think about to housekeep as to how we go about these matters which we have been going on. I mean, there has been considerable time which has been spent by
Mr. Pandey can have a liaison with the
your lordship.
here.
Yeah, your lordship, I just only wish if that much time was spent during the arbitration, at least we would have also cross-examined
Right,
these.
exactly.
Nevertheless,
precisely so.
Yeah. Nevertheless, your lordship, today we are discussing whether an award is to be enforced.
Obviously, ultimately, it boils down to written notes.
Yes,
it's not possible for me to retain humanly all these arguments in my mind.
Exactly, your lordship. So some way out, if the senior members of the bar themselves can tell us or guide us as to how they can do it.
They can guide you only if you have a formal conference.
Yeah.
Yes.
So, Lord, we again say, please rule on jurisdiction. And then it's challenged on the following grounds. Premature Lord Constitution, I won't trouble your lordship with. Not I believe someone else will argue.
Yes.
Will trouble your lordship. Then, my lord, if your lordship comes to,
Functus officio was on because the tenure was over.
yes, tenure was long over. Your lordship remember 60 days. I made my
Yes, 60 days,
detailed
right.
submissions on that, not.
Yes, yes.
Bold one. But then, not please come to 1459,
Yes, I'm there.
2.2.
Functus officio.
But functus officio, I've argued, I won't
Yes,
trouble you.
you have,
It's
yes.
taken. But I'm pointing out that all these points, Lord, were
Right,
raised.
right.
Then, my lord, 1462, non-arbitrability of the dispute,
Yes, yes.
bar under the Companies Act. My lord, again, I'm not troubling your lordship with this point. My lord, I'm only concentrating on the 3 points which I am doing, my lord. Then, my lord, 2.3.2 is elected to pursue remedies before NCLT. I'm again not doing this point. This is the waiver point. Waiver point. Then, my lord, please come to this is the one which I am doing. But 2.3.3 at 1466.
Egregious for.
Now, Lord, I'll just place this because it's a good summary. Otherwise, not whoever has drafted it has not actually done a better job than our summary. I didn't have access to it, or rather, laziness. I hadn't seen this earlier.
Right.
But the claimant, along with its principals and the holding company, along with principals, hatched an intricate conspiracy. Modus operandi was achieved by deceiving and inducing respondents to exchange shares of Glocal for shares of NYSE listed upheld things. Such shares, apart from being encumbered and as such not qualifying, were inflated by false valuations, then misrepresented the value. Not your lordship can skip that. Equity value, not that entire background is set out there, and your lordship will find the charts there of how the valuations come. And my lord, if your lordship goes to 1468, this is not again this the valuation, it's not inflated. Why it was actually only half of what it was represented to be. That's 1468. Then not the last para of that page, not at 1468 bottom.
Yes. These
acts led to an SEC inquiry being initiated against the claimant and its parent company. So not under investigation in US also. Not the equivalent of our SEBI. The shares of Uphealth were worthless, dud to begin with, and they did not have the underlying cash to support them and were backed by completely false valuation by the claimant and projections that they were never achievable as there was no money to support the growth. Claimants knew that shares of Uphealth to be worthless and therefore elaborate swindle was enacted to defraud.
This does not indicate the status of that SEC. Probably still ongoing. I don't know.
Possibly. Whereas the shares of respondent Glocal, yes, it's. How do you show that?
No, you can tell it's ongoing.
But that's what I understand. But on instruction.
If it had culminated against them, then it would be very relevant. But
still ongoing. Perhaps not.
Perhaps yes.
Not my learned friends will also know it better.
Definitely they'll be.
Then my claimants always knew the shares were worthless, therefore elaborate swindle, etc. Local health had solid proven value backed by going concern, profitable business, fixed assets. The report of Agarwal Nangi Amlad is referred, Agarwal Lodha is referred to over there. Thereafter, from the trial court's order in New York, in the case brought by Needham, it has been, this is another case. Now here, your lordship will remember, when we did the damages portion, Needham was the person on whose valuation everything was based. Now this Needham, he was owed 42 or 31 million in fees, which they did not pay for preparing those valuations. They did not pay those fees. So he filed an action for recovery. Now, there was a decree. Against that, an appeal was preferred. To get around that decree, bankruptcy was filed. They filed bankruptcy to get out of that decree.
That is not there in this letter.
No, it's there. It's there. They filed bankruptcies, then the award itself.
The bankruptcy they filed, yes, obviously.
Yes. And it was filed by Needham also. There was a self-bankruptcy also, that also I'll show. Thereafter, from the trial court order in New York, in the case of Needham, it has been made clear there was an additional obligation pertaining to the transaction itself over 31 million. Thus, so now we are using it for a different purpose. That let's say if you showed 1,000 million worth of funds. Actually, 31 was due to someone else. So your funds were less to that extent. Thus, they did not have the money to operate when they signed the warranties.
This is an extension of the previous things. I mean,
They didn't have money to pay the person who prepared the entire basis of this, structured this transaction.
Yes.
They did not have the money to operate when they signed the warranties. Report of the independent expert, Alvarez Marshall, has brought out events related to the fall in share price based on public filings, none of which is attributable to the respondents. Then, to put this in perspective, claimants fraudulently gained access to so many percent of the shares by paying only 13%, etc. Then, those option agreements, 110 million, that's there. I won't trouble your lordship. Then, next page, learned commercial court at Rajarhat passed an order on 31st August, whereby though the court refused interim relief, it returned a fundamental
That prima facie case of fraud.
Yes.
That,
Then, thus, a Indian competent court hearing an anti-arbitration suit, having returned a prima facie finding of fraud, etc., renders it inarbitrable. And I showed your lordship how they went around the whole thing.
that was prima facie. That was prima facie, but
Agreed.
circumstantially, yes.
Agreed. But
Taken together with the other things.
read together with the fact that my injunction application was to be heard. They came up in revision, stayed the proceedings, then the proceedings get dismissed before that award passed.
Yes.
That is the suspicious part. Thereafter, criminal investigation into this fraud is underway. FIR West Bengal, pending criminal investigation, past conduct, court rulings showing trend to defraud and prima facie Indian court, etc. Honorable Tribunal is urged to dismiss the claim at the threshold for the underlying dispute being non-arbitrable on the grounds of egregious fraud, SEC investigation, police investigation in India, which started the process of getting letters rogatory issued to United States Department of Justice, finding of an Indian court that this criminal fraud requires a full-fledged trial, completely fly in the teeth of this dispute being arbitrable.
The tribunal did not deal with the question of
Jurisdiction deals with saying
regarding this aspect of the matter.
No, it never goes into this aspect properly. What it says is one, you have not presented it properly. I'm putting it very crudely. I'll show your lordship the paras. I'm not. I have to show you.
No.
One is it's not presented properly. Two, fraud requires a very high level of proof. Third, the issue of jurisdiction has been decided 3 times over earlier. Emergency Arbitral Tribunal's interim order decided it. Justice Ravi Kapoor in the Section 9 decided it with regard to NCLT, and another interim order has decided it. It does not decide it on its own. This is how it approached it. So, please see the last line on that para. To oversimplify the criminal fraud perpetrated, an illustration is presented. Now, whoever made this illustration explains it very nicely. Party A gives 13% consideration as advance to buy a property from Party B and gives post-dated checks with a stated value of 87%, and in turn gets a title issued. So he's become the owner, or he gets the certificate. When the check becomes bankable, it's found that Party A never had 87% of the value in its account and does not have it at the moment and never will. So this is put very nicely, I thought. This is exactly the frame of what happened. Then, the next few things I just skip through. Conduct of the claimant. So, there's concealment, suppression, and if your lordship keeps going through, comes to 3.1.6. We are showing that. That's at page 1474.
Yes.
Claimant has suppressed governance of the option agreement and lockup agreement to put a curtain on its false statement that the entire consideration was paid. So, their pleading in the statement of claim is the entire consideration has been paid. I'll show that to your lordship from the statement of claim. That is at para 346 of the statement of claim. Your lordship can make a noting saying that full consideration has been paid. Now, please remember, admittedly, 100 million minimum was to be paid to me, minimum, by way of value of shares. With the lockup agreement in place, I never got it. The day it became marketable, it was less than 10 million. So 100 million shortfall straight out there. No explanation for that. They say full consideration has been paid. That's their case. Now, what they suppress is, they only rely on the SPA. They don't suppress the later agreements, the option agreements, etc. Now, my lord, 3.1.6.
Difficulty is, Mr. Bachat, you played an ostrich. I mean, you took the jurisdiction point and then you
I say decide it at not prima facie. Order 7 rule
cannot
11
be
issue.
adamant on that. If it does not decide, you have to reserving that.
I'll be reserving one part of my argument on that the arbitrators were bound to decide it. You can't not the arbitrators played ostrich here. I may have played ostrich, but not.
Yes,
Yeah.
but then there's nothing. If you take a risk, if you lose on the jurisdiction point,
Yes.
then there is nothing on record. Most of your pleadings are not on record as such. Your documents.
They've treated it as pleading. They've treated it as a Section 16 challenge. They've treated it as jurisdictional
On
challenge.
merits, you have got
The
no
other side has
defense.
dealt with it. I am not going on merits, I tell you. So your lordship ignores this part on merits. It's all right. I am only trying to show that I had raised a prima facie view that, look, I have alleged fraud, I have filed criminal proceedings,
Yes.
courts have taken cognizance. Now, in view of this, they should have held, look, I can still proceed with it, or I cannot proceed with it. There's no finding on that. Not I may have played ostrich, but the arbitrators couldn't have. Arbitrators, it's well known, have to decide jurisdiction. Have to. Now, a whole set of judgments will say, look, decide it at the threshold. There are judgments which may say, well, he has to decide, but he has to decide sometime. It can't be that it's never decided.
No, if it's non-arbitrability, then it hits at the root. I mean, at the inherent
Correct.
lack of jurisdiction.
Correct.
Subject matter jurisdiction also.
Correct.
So
Absolutely.
that might not be taken at the necessarily be taken at the inception. Might be taken later probably because that's inherent lack of jurisdiction. If I don't have inherent,
lack of jurisdiction,
could have taken it later also.
But let me put it this way, inherent lack of jurisdiction. But again, it may not be the correct example, but let's look at proceedings in a suit.
Yes, yes.
Now, where I say it's not a lack of territorial jurisdiction.
That is precisely what I say. Unless it's pecuniary territorial.
But if I say it's lack of subject matter, for example,
subject matter jurisdiction,
a civil court cannot decide a particular thing. Let's say revenue matters or whatever.
Territorial pecuniary at the threshold. But subject matter jurisdiction, inherent lack of jurisdiction, this forum does not have.
Yes, correct. So, that is actually more of a point of maintainability, which
that
can
hits
be
at the root
decided
of the jurisdiction.
at the very beginning. So, I may have been the ostrich. I'll show your lordship. I think I found somewhere your lordship asked the question, why did you not go? Now, there is an interesting explanation somewhere over, maybe in this only. I'll show that to your lordship. There is some explanation for it. I thought it was lack of funds because the bank account had been injuncted by the Emergency Arbitral Tribunal.
Yes, you said that.
I said that. Yes. But there is an additional reason over here. 4.4. I'll be coming to that. It's over here only.
So just for the record, your lordship, we had paid the entire tribunal's fees. The tribunal's fees was an issue that we had paid it, considering we waited for them.
Yes, Mr. Bachat said that. Para 346 of the SOC.
346. Yes.
Now, OS closing was never achieved before because the consideration was never paid. Claimants know that OS filing was never achieved and shareholding was jettisoned by the way of issue of additional shares, etc. Same was at the claimant and upheld persistence that until the claimant held 90% shareholding, they could not get the SPAC upheld and get listed on NYSE. Therefore, they have concealed the option agreement in order to read the SPA in isolation and misrepresent it was complied with. Now, 3.1.7, further consideration was never paid because there was a lockup agreement. Then, my lord, SPA, I've showed your lordship the clauses. There was a clause saying that these will be free of encumbrance. That's not the next clause. So these were warranties. But instead, we were hit with the lockup agreement. Then 3.1.9. This is that minimum $110 million. Then Part B, acquire warranties. Your lordship will find at the clause 7, 5th line. These were to be freely tradable.
Yes, freely.
Instead, we are hit with a then 3.1.10. Not 3.1.11, Lord, they became non-marketable and encumbered because of that lock-in agreement. All of this. Then, my lord, your lordship, there's a section on perjury. I'm not going into that. If your lordship not, then comes to clause 4.2 at 1491.
Yes.
Claimant counsel writes that the respondent local continues to be represented by counsel in arbitration. This is completely untrue. So we are not being represented. We are making it clear we are not participating. Respondent local is not represented by any counsel. A major reason for this, so this is that reason your lordship asked me about. Good or bad, I don't know, but it's a major reason for this is also litigation-induced financial cash flow constraints, as the respondent has to prioritize saving lives and delivering healthcare in remote areas over anything else. And the present proceedings, which were switched over to after the claimant submitted to the jurisdiction of NCLT, are utterly oppressive and vexatious. Therefore, respondent has been prevented from seeking effective legal assistance and counsel, etc. And then, Lord, that box of documents. Again, Lord, this is also dealt with. So, sent to everyone aware of it. Then, my lord, your lordship goes to para 4.5. So, now, my lord, we give the legal authorities. Russell and Russell has been brushed, so English authorities cited about non-arbitrability of certain disputes. Now, the Supreme Court had said, not it's an old view. So, Russell has been attempted to be brushed off as being of the year 1880. It is submitted. Russell lays down a time-tested proposition of law, which is followed by Indian courts and was cited by approval in a three-bench judgment of the Indian Supreme Court, Delhi High Court. Law in India is still that where there is a serious fraud, such as at present, the same would undoubtedly render the dispute arbitrable. So, my lord, again, then, my lord, authorities are cited. My lord, I won't trouble your lordship. And then, my lord, para 4.6, just above that, my lord. Finally, coming to Lazarus Estates, the principle fraud unravels all is a time-tested principle which has been consistently followed by courts in India. Then, my lord, if your lordship comes to 4.8, please see again. This is important because not all through I've been saying decide. Inasmuch as the claimants are ad idem, and claimants were also saying so, that the tribunal ought to rule on its jurisdictions. The respondents agree and request the tribunal to first and foremost consider the above submission and rule on jurisdiction before proceeding to deliberate on merits. So, these facts were there from beginning to end. We'll do that.
So I'll be coming with
No, I'll go to the award later. 123. Yes. Yes. Now, my lord, if your lordship just comes to the award, just to finish off that chapter, that this letter was considered and they were asked to react, just two paras, or your lordship can make a note of it. Page, so what the key of it, page.
Petition. Yes.
The award, my lord, if your lordship comes to para 124. Or 123.
Hmm.
So, my lord, para 123 onwards, Claimants Council responded on 19th November. Claimants Council responded to respondent's email of 15th November. Then 27th November, they gave some documents, legal authorities on behalf. So they're dealing with it in detail. On 29th November, Claimants Council objected to respondent number 4's email dated 27th November and attachments. So, my lord, all the attachments given with that are also now dealt with. To show your lordship that this is all dealt with. And yet, no finding. Now, my lord, the award I'll come to last. There's one last thing I show your lordship before I come to the award on the jurisdictional point, the findings on it. Now, your lordship will remember it refers to that Cody Laidlaw judgment. Now, just have a look at that once. It's interesting for a few reasons. So, this is decided on 1st March 23. Long before, my lord, the arbitral tribunal renders its award. My lord, please come to para 2. My lord, the first para on the second page.
Yes.
This decision considers a motion to dismiss breach of fiduciary duty claims against directors and controlling stockholders of JIC Capital 2, which is this company, a special purpose acquisition company. Now, my lord, please see the next lines. At first glance, readers may think I inadvertently republished an earlier decision. But may I pause here? Interesting spin-off. Yesterday's newspaper had something
Day
about
before yesterday.
copy-paste. Yes.
Day before
Yes,
yesterday.
about
I
copy-paste.
Immediately reminded of that.
So was I. So, my lord, at first glance, readers may think I inadvertently republished an earlier decision. The legal theories presented and defendants named are largely indistinguishable from those in this court's recent Delman versus JIG Acquisitions 3 decision. So, another, my lord, JIG Capital, another one. Same, repeat. But a different JIG Capital affiliated SPAC is my present focus. So, my lord, this is to show, my lord, there's a previous history. It's happening again and again. And the judge is not conscious and he says, look, it's not a copy-paste thing. It may seem to be. Now, Lord, I won't trouble your lordship with large amounts of it. Lord, your lordship can come to page 3 of this. JIG Capital to its sponsor and its board. And your lordship will find it's not given there. Founder shares, all that. Lord, your lordship has already not found a summary of it. I won't trouble your lordship with all this. Then, my lord, if your lordship comes to Lord, G, page 10.
Yes.
On 13th May 21, JIG2 filed its definitive proxy statement concerning UpHealth and Cloudbread mergers with the SEC. Stockholders were invited to vote on the mergers and related transactions, including PIPE and notes deals at a June 4th special meeting. Stockholders were also informed that the deadline to redeem their shares was 2nd June. So, Lord, 2nd June was the date by which they could have withdrawn. If they withdrew, Lord, 4th June, it would have failed. Proxy explained that redeeming shareholders would receive approximately 10.10 per share from the trust, and that is that trust money. And public stockholders may elect to redeem their shares even if they vote for the mergers. In several places, Proxy indicated that JIG2 shares were worth $10 each. Proxy explained that the consideration was to be paid at UpHealth to UpHealth and Cloudbread equity shareholders, consisted of JIG2 stock valued at $10 per share. Pro forma financials referred to JIG2 common shares to be delivered at $10 per share valuation and to the negotiated market price common stock at $10. Elsewhere under the heading calculation of purchase price, Proxy stated that JIG2 would pay not 990 million to Uphealth and its shareholders by issuing 99 million shares of common stock, implying a $10 per share value. Proxy also warned of a minimal risk of dilution caused by mergers and pipe. Now, Lord, please remember, in my case, my agreement had something more, a warranty that it would be worth a minimum at all times. Now, Lord, so, Lord, this is the background. Then, Lord, I won't trouble your Lordship, Lord, with a lot of this. And if your Lordship comes to, Lord, page 20. See the allegations being made here, Lord. And it gives the motive why they were not about why what happened. The plaintiff further asserts that competing interests arose in the context of redemptions. After the merger agreements were signed, the sponsor had an interest in minimizing redemptions because deals were conditioned on JIG2 having at least 150 million in total cash. By minimizing redemptions, sponsor reduced the chance that mergers would fail. Fewer redemptions would also decrease the value of the sponsor's interest if the mergers closed. Thus, the sponsor effectively competed with public stockholders for funds held in trust and would be incentivized to discourage redemption if the deal was expected to be value decreasing, as the plaintiffs allege. The essential conflict alleged in the complaint arises from the sponsor's motivations to avoid a liquidation and to discourage redemptions in order to maximize the amount of cash in trust for funding of mergers. Plaintiff asserts that sponsor reaped tremendous upside from the mergers while public stockholders lost value. Upon closing, founder shares were worth more than 37 million, a 1,47,900% gain on a $25,000 investment. Those shares were still worth 15.5 million as on the date of filing of the complaint. Public stockholders were, however, left with shares of 3.75 as of that date rather than 10.10. And this plot 3.75 also went down. This was the motive, not prevent others from going out. I milk my money irrespective. And then, my lord, if your lordship sees allegations of breach of fiduciary duty, etc., all of that is made. And then please comes to page 27.
Yes.
Plaintiff here alleges that an even wider gulf between the value per share public shareholders were told to expect and the SPAC's net cash per share. Proxy represented that they were worth not $10 each. Plaintiff maintains, however, net cash was 5.19. Thus, which is in lines with all the reports we've given, your lordship. Thus, the proxy statement that JIG shares were $10 was false or at least materially misleading. Given the difference between the proxy's representation and the net cash value, JIG shareholders could not logically expect to receive $10. And the point here is to show they knew it. That's not good enough to show fraud. Proxy disclosed some information relevant to public shareholders' assessment of the value underlying JIG2 shares, but that information was incomplete and strewn across various pages, making it difficult even for a sophisticated investor to discern.
The answer to my query to you. Yes.
The proxy should be lucid, not a game of clue. So, my lord, it's put nicely.
Yes, yes.
And then, my lord, if your lordship comes to page, yes, page 32. As discussed above, the plaintiff sufficiently pleaded that CATS was self-interested in the mergers and other directors lacked independence from CATS. Plaintiff asserts that defendants were motivated by these interests to discourage redemption and ensure mergers closed. Doing so would yield a windfall for the sponsor, but a loss for public stockholders. Thus, plaintiff's claims concerning materially deficient disclosures are inextricably intertwined with issues of loyalty. These claims are not exculpated, etc. Then, not unjust enrichment. To state a claim against the sponsor and the board for unjust enrichment, plaintiff must allege facts making it reasonably conceivable that defendants received unjustified benefit at the expense of JIG2 stockholders. Unjust enrichment, not that the law is there, I won't bother your lordship. The next para, the complaint provides grounds to infer that the defendants were disincentivized to incentivize to enter a value destructive de-SPAC merger that allowed the sponsor to make colossal returns on a nominal investment. Defendants were also motivated to minimize redemption by issuing a materially misleading proxy statement. Sponsors' gain purportedly came at public stockholders' value. Unjust enrichment claims are therefore reasonably conceivable and survives along with the fiduciary duty claims. So, again, this is showing three things here. There is not enough to show that this is a modus operandi not attempted by Mr. Avicats and the JIC companies not again and again, and they do it in such a manner that it is not impossible to catch. But it's a repeated, not a string of offenses. I've showed your lordship, JIC capital 1, 2, 3, 4, 5. And in this case, he's talking about there having been an earlier JIC capital 3 and this JIC capital 2. But this whole history, I will not read it. This is the other one. But he refers to it as being virtually copycat. So this is that one. G capital 3. Same modus operandi, same everything. And not the fact that it is under investigation in 2 countries. But more than anything else, please look at not just this conduct, but not also this course of conduct of bankruptcies, consistent bankruptcies. I am sold a deal. I get into the deal. The companies declare self-bankruptcy. The other companies which are to come in, I've showed your lordship, have also gone into bankruptcy. And the charge of misrepresentation against us is rejected by the arbitral tribunal. So, no blame.
Your jurisdiction argument was on one is that non-arbitrable because of fraud. And second is that functus officio. And what else on jurisdiction?
First I did functus officio.
Yes.
But the other jurisdictional points, the first point was NCLT proceedings filed by us.
Yes. So section 430, you cited 430.
I have not.
That was taken.
I thought your lordship was asking about our jurisdictional challenge. That point will be addressed by someone else. I have not dealt with 430 at all.
Very well. So NCLT proceeding was one of your grounds.
Yes, one of the grounds over here. Yes.
In your jurisdiction,
the first point on jurisdiction taken is NCLT 430, and read with that, they applied in that 430 and asked for reliefs in that application. So, waiver of the arbitration clause, they accept it as the forum. They accept NCLT is the appropriate forum, and they make that statement in that application, saying that the NCLT has jurisdiction. And, my lord, they say so in a declaration made before the SEC over there also, that there is litigation before the forum having jurisdiction. And that they intend to pursue it. So, this was the first point. Bar under statute.
Yes.
Now, the way it is dealt with by
what other points? The jurisdiction points?
The second point was, I had filed an anti-arbitration suit. Rajarhat Commercial Court. The third is...
There you did not have any interim order, obviously.
No. They preempted it. They preempted it by filing an application for stay on the ground that the parent company has gone, or that company has gone into...
That stay application was refused. They came up before this court and got a stay.
Yes. But that stay application, I give you lordship, the basis was not that the suit is not maintainable. They asked for a stay on the ground of bankruptcy. Bankruptcy-related moratorium on proceedings. That was rejected by Rajarhat Court. But before our interim application could be moved, they moved the High Court and got a stay of proceedings. Then,
stay was lifted, but by then the...
Not only stay lifted, it was held that there could be no moratorium at all. But the moratorium did not operate on this. Findings, specific findings.
But then it was too late.
And proceedings restored. By then, not the deed was done.
Award was passed before that.
Yes. And not the last point on this, which is what I was seeking to argue now, is not fraud, egregious fraud rather, not which is the subject matter of criminal proceedings. Court has taken note of this and said charge sheet has been filed, investigations underway, and not letter is rogatory. Not that process was also underway at that time. All brought to the notice of the tribunal.
4 jurisdictional objections, NCLT, anti-arbitration suit, functus officio, and this.
There's a fifth one. There's a fifth one, which is to do with not the steps to be taken in arbitration before you can commence not arbitration. Those steps were not there.
Steps had to be taken by dint of what?
Sorry.
In the SPA itself, there was certain pre-arbitral
steps. Yes. Steps taken, not steps to be taken under the arbitration clause were not followed. But those aspects are all being done by someone else, not so. But I have largely dealt with the issue of fraud, and which is not the largest area.
Yes.
The entire thing builds around not what the transaction was. So, not again, I'll not take your lordship's time. I'll summarize my argument on this. I was induced to enter into the agreement by fraud. The execution of by execution, I don't mean the signing, but the implementation of the agreement was also fraudulent because they made changes along the way. There was suppression of material facts, including the fact in which there was lack of funding, not lack of transparency by which I could have detected it, failure to disclose that at least 2 of the transactions which they showed me as bringing funds in were non-existent, failure to show that the whole deal would have flopped but for this artificial means by way of a forward purchase agreement. The fact that there is a continuous history of doing it, all this shows this was known to them, and not at least falls within not all known definitions of fraud. So, not fraud in not inducing me to enter into the agreement, in implementation, thereafter, my lord, the manner in which these legal proceedings have been taken across the place, preventing me from first submission over here to arbitration, then seeing, look, NCLT, we have submitted there, despite that, go to arbitration, and immediately first block the bank accounts. Blocking of the bank accounts, not the manner in which Rajarat suit was not literally scuttled.
Blocking of the bank accounts was how? I mean,
they went to emergency arbitral.
Oh, that emergency.
Yes. Long after NCLT, my lord, I go to NCLT. Then, my lord, criminal charges brought by me. Not after filing of the FIR, suddenly one fine day they invoke arbitration. They ask for emergency arbitration and they block off funding. Then, my lord, the moment the Rajarat suit is becoming uncomfortable, bankruptcy filing to claim moratorium. So, stop my anti-arbitration suit by any means. Yet, Lord, they will proceed with the arbitration despite this moratorium. They don't bring this to the knowledge of the arbitral tribunal, but they come to India and they say, stop these proceedings. I bring it to the knowledge of the arbitral forum. That I've showed your lordship already. So bankruptcy, and bankruptcy aimed at what? Preventing me from getting back my rights because I can't fight back if there's a moratorium. So fraud right from beginning till the end. And not preventing my jurisdictional point from being decided. So, this is the long and short of it. I'll take 5 more minutes if your lordship permits today to now take your lordship through the findings in the award. अरे 210 से चालू करें Don't want me to repeat that. Okay. So then start from 234. 28 onwards. Okay. Sure. But large chunks of the award have already been shown, but in the context of also damages and for showing your lordship that, look, I was taking the point, they were asked to react and all of that. So I won't trouble your lordship with all of that. And if I can just show your lordship about 7 or 8 paras on this. Your lordship would come to page 101, para 228.
Yes. Yes.
Additionally, members of the tribunal have been sent unsolicited boxes of documents by the respondent to the office of the tribunal members or on or around early December and February 24. So these are additional ones. Claimant informed the tribunal that these boxes have not been served on them. It would be improper for the tribunal to consider such unilateral communication. The respondent must be aware of the impropriety of such communication as they appear to be professionally advised at all times. Parties shall not engage in oral communication is what the Amnot guideline says. Then, Lord, through the above mails, respondents and non-parties have made various allegations entirely disregarding directions and established procedure of making submission in these proceedings. Now, but they've obviously looked at these mails, otherwise what we have
Why
done.
didn't you file it formally?
These were filed formally.
Emails were sent and all.
But
because the POI clearly provides that there will not be any communication privately.
I tell your lordship, the way of filing is by emails. Now, I have sent emails as required.
The tribunal has a different email ID, or it was sent to the panel members.
I'm not clear.
Because they say specifically that private communications are
how it applies, I'm not clear on it.
Anyway, so let us see.
But the whole thing is this doesn't apply. Parties shall not engage in oral communication.
And it was not a private communication or something private. It was
ex parte. This is not ex parte.
And it was in connection with the arbitral proceeding itself. Nothing beyond that.
And it was not ex parte. The rule says ex parte. I'm sending copies. This is to do with ex parte.
Yes.
Through the I've showed your lordship. I'm sending mails as they ask to respond. They respond. Through the above emails, the respondents and non-parties have made various allegations entirely disregarding directions and established procedure for making submission in these proceedings. Respondents' entitlement to refrain from participating in arbitral proceeding does not mean they have an absolute right to pick and choose the moments they may intervene in the proceedings. The first batch of unsolicited mails were sent on the eve of the evidentiary hearing. Similarly, the email by CEO Local Office was sent on the eve of the hearing on 9 September 23. Now, Lord, please make a note that this was the first evidentiary hearing. I'll show your lordship the number of filings they have done after that. Much more than mine. Your lordship knows that entire thing was going on. Look, you don't have enough evidence. Can you give some more evidence? Please give some more evidence, additional evidence. So, the entire chapter actually unraveled thereafter. They find fault with me sending a letter on that day.
This was on an entirely technical premise.
Correct. Then, although they have granted multiple opportunities to participate, respondents did not formally place their objections before the Constitutional Tribunal. Instead, they unilaterally sent, or it appears, procured shareholders, employees to send emails to tribunals. Emails and boxes of documents were sent only to the tribunal without copying to the claimant. I've showed your lordship that's incorrect. These unsolicited emails and documents do not elicit any bona fide intention to meaningfully contribute to the proceedings, but rather appear to have been laced with intention to disrupt efficient and timely conduct of the proceedings. But the evidence by the claimant is not even over by then. They keep on giving newer things. How am I disrupting anything? They have in no small way added to the time taken to address them, delayed finalization of the award, and increase the incidental cost. Now, my lord, please see this portion of not this sending boxes unilaterally without permission, not how much it is contradicted by the paras I showed your lordship earlier. That para 122 where 120 is, that was para 120, na? Just check that. That we have given the boxes and all that. Yes, that was not contradicted by 120. They don't say it's false. They've recorded it in their award. They record the fact that look, it was sent earlier. It was being sent again.
And we say that all were given copies, emails and hard copies, and responses were sought. They gave the responses.
Correct.
So after that, probably this would be, I mean,
Absolutely.
this has become academic only.
This is just a way of getting rid of it. Not this is playing ostrich.
But then page 493, they start dealing with it. Probably.
Yes, I'm reading it all. Not, I'm reading it all. I'll paste
Paragraphs
this.
have been devoted unnecessarily, yes, on technical.
Not I can read from 231 onwards. Not the relevant paras would go up to perhaps para 271. Now, your lordship will just one. Not the in 231, your lordship will find their argument on this is there. The other side's argument. If your lordship comes to para 231, the second page of it. So, apart from the judgments, about 6 lines from the top.
Yes,
Sadly,
yes.
tribunal is unable to even make a finding on this matter since respondent failed to properly articulate its position in accordance with procedural timetable established for these proceedings. Now, did the claimant do that? Claimant continued not giving evidence till after closure of our arguments. I've showed that to your lordship, right into December and January. Tribunal when it was for the tribunal to not decide it in 60 days, it did not. And I'm not sticking to deadline 1 year after that. In this regard, the claimant argues no respondent has clearly articulated to the tribunal any claim of fraud in connection with the original SPA. But this is as incorrect as it can be. I've been saying fraud from the beginning, Lord. I've placed Lord, even the last letter and the letter they have set out. Not at para 120, your lordship remembers, they've set out the letter saying, look, my jurisdictional points are the following, including fraud and criminal proceedings are pending. In the tribunal's view, it is inconvertible and globally accepted that a party seeking to rely on a particular fact has the burden of establishing it. In the present circumstances, burden of proof is in the respondents to establish fraud. I'm not saying you've come to a finding on fraud. I'm saying decide jurisdiction because this fraud is the subject matter of criminal proceedings. You do not have the right to adjudicate. I'm not required to prove anything to the hilt. I say you don't have seisin because
They'll have to show that detailed questions of fraud are involved, egregious fraud.
And it's being taken seriously by the authorities.
Because if you had to prove fraud to the hilt, then you would be submitting to the jurisdiction and doing it before.
Correct. I could not.
You only had to show that there are ingredients of fraud, which cannot be decided.
Maybe a little higher than that, but let me be frank.
Yes.
Little higher than that. But there are allegations of fraud. These are being investigated by the authorities because they're serious enough. It is not as if it got quashed on the application.
Right.
But a court applies its mind to it. The criminal court also applied its mind to it.
Right.
It is further argued by the claimant that the law on arbitrability in India has evolved since Russell and Russell. Claimant submits that the more recent Supreme Court judgments on Avitel rejected arguments of non-arbitrability and fraud on the basis that mere fact that criminal proceedings can or have been instituted in respect of the same subject matter would not lead to the conclusion that a dispute which is otherwise arbitrable ceases to be. So, please note the word mere fact of filing. Here it is gone much beyond that.
But you say much beyond that, there are prima facie findings only.
But this is mere fact of filing, that they can be instituted or have been instituted. Ours has gone much beyond the institution. It has crossed that. Charge sheet has been filed. after application of mine by a criminal court. Cognizance taken, letters rogatory. Not, this has gone well beyond that. In the tribunal's view, on the basis of the material provided, there is plainly insufficient evidence to reach any finding of fraud. I'm not asking them to reach a finding on fraud. I'm saying decide jurisdiction. But they've clearly applied the wrong test. Tribunal notes as an aside, any allegation that the SPA was entered into fraudulently may also entail, as argued by the claimant, the respondent returning all sums paid by the claimant. So he's going on merit here. If I say fraud, return the money. I'm willing to give back everything, all the losses. Pertinently, the claimant states, inter alia, following with regard to any allegation that fraud unravels all. Another possibility is that by saying fraud unravels all, respondent local is suggesting transactions underlying the disputes were entered into the basis of fraud. Therefore, they say, return the money. They say, look, I've given you 185 million, 22 million, and 110 million, and 35 million, return 185 million. This is what they are saying here. Please see, claimant paid approximately 185 million total in cash and stock to the respondents. Not the last 6 lines of that quotation. To the extent the respondents propose to unravel the transaction by returning 185 million, this is indeed an appropriate number for the tribunal to bear in mind to consider the quantum of damages. Now, my lord, is this a finding on jurisdiction? Further, at no point of time did the respondent ask for any extension of time to submit pleadings, etc. So, my lord, this is not to do with fraud. On fraud, if your lordship wants to see, which one?
You had not taken out any application formally challenging jurisdiction.
But I'll tell you a lot. No, I'll tell you a lordship how it started.
You only sent the emails and all. You did not take
I'll
any
tell you a
formal
lordship how
application.
I'll tell you a lordship how it started. It goes back one step earlier. Not before the emergency arbitral tribunal, we took the point.
That was turned down.
They say for the purpose of the application. So for the purpose of our section 17, we are deciding we have jurisdiction. It will be decided finally. So we write to the, not then the, what's the body above the tribunal called? The commission of, the ICC court. Now thereafter we write to the secretariat saying, look, we have this jurisdictional challenge. They said, look, we can't decide it. It will be decided by the tribunal. So that's recorded in the award. I'll show that to your lordship. So they said it will be decided by the tribunal. So then, Lord, all through we kept writing letters. I'll give your lordship a chronology of the letters. And Lord, as time goes by, because they are also now taking time. Now I put in Lord one report, a second report, opinion of the Lord Supreme Court, because they were showing no signs of deciding before that. So Lord, at about the time when they decide that now we will start hearing the main matter. Before that, procedural steps. So when they are getting into it, we said, look, decide jurisdiction now. That's when we send the legal authorities. That's happening in about July. Which one? We will go there. We'll go there later. Let's just finish this part of it. Then, my lord, para 232. Further, at no point of time the respondents asked for any extension of time to submit pleadings. Instead, they have simply sent emails on various points in time without making any effort to appropriately support their claims with relevant documents, etc. So, my lord, they are not saying that, look, there is no application before us. They are trying to decide jurisdiction. But they say, look, you have not been able to prove it properly. And they say there is no relevant evidence or documents which is fairly served on the claimant. Now, my lord, how do I fairly serve something on the claimant? No relevant evidence or documents fairly served on the claimant. So they are there. They are before us, but they are not fairly served on the claimant. Now, where does he get this?
But the next sentence clearly says that your efforts should have best been served
by formally participating in the proceeding.
And making submissions regarding their concerns.
Yes. So they are saying
So you
participate.
could have just appeared and taken out the jurisdiction point by an application.
They say appear.
It's like shadow boxing. You're just sending emails, writing
not,
letters.
Let me put it differently. I mean, arbitration, arbitration is a place where formalities are generally all dispensed with.
Right.
I need not appear through counsel. I need not make oral submissions. I can give written submissions. I have done so.
But you have letters and sending emails.
They
containing
want
boxes.
formal participation. Come participate.
No,
which
it
would
has
be
to be read in conjunction with the next part of the
very well.
submission.
I'll read that. Not,
Formally participating and making submissions regarding their concerns about
not
jurisdiction.
my concern. They would say, look, we will do it all together. That's what they've done. We will decide finally. So now you make your submission on merits. But this is a way of dodging a decision on jurisdiction. I would say it is most improper conduct. But they know that the issue of jurisdiction is there before them. It's been put in writing not once, but by not numerous times by different respondents. Ignore not the shareholders. Different respondents have put it
You're
in.
right, because in arbitration it has to be informal. That's the purpose.
But they were very much in
They
seizing
were
on
aware of
it.
the objection.
And not they asked,
They took responses also from the
they
other side.
took responses. They've heard they are dealing with the cases. But they're dealing with the cases just above this. Your Lordship has seen.
Yes,
And yet avoiding the issue.
right.
Unfortunately, respondent made a deliberate decision not to appropriately participate in the proceedings. Respondents have instead made broad and sweeping allegations and sent documents without categorizing them or copying them to documents to the claimant. Now, my lord, this is as broad as it gets. Because I'm saying I've sent it not once but several times. And not a broad sweeping statement, and I'm accused not of sweeping allegations and send documents without categorizing or copying them. I'm not use of the word unfortunate, but it is perhaps not, I don't know.
That is unfortunate. User of the word is unfortunate. Yes.
Now, but the other part here,
224, 234 probably they start dealing with it, or
yes, now come to 234. my lord.
yes.
This is also an appropriate juncture to briefly address certain arguments raised by the respondent. So now, my lord, they are also dealing with the argument, so it's not as if they did not take cognizance
Right.
at all. On the one hand, you say not proper, yet we deal with it. The other objections which go to jurisdiction are discussed below while determining the tribunal's jurisdiction. First, alleges perjury. But please leave that. I'm not.
So they are saying we are determining, are discussed below when determining the
Yes.
tribunal's jurisdiction.
Yes.
But you have argued that they did not decide.
Please
But they are
see.
saying that we are deciding.
Please see. Please
Yes.
see. Not 235. 234 is to do with perjury.
Yes.
That is fraud in arbitration. If they are guilty of perjury, they are guilty of perjury. It is one more component of fraud.
Yes.
Now, please see what the allegation was. The third line. First respondent, number one, alleges guilty of perjury on the basis that there was option agreement along with SPS which provided for transfer of shareholding only after receipt of full consideration. Respondent number one asserts that claimant has concealed these option agreements and other relevant facts and is inter alia misrepresented loss of control of the company. Second, respondent number one argues that claimant is guilty of criminal fraud in India. Now, let's mark this. And as such, issues are non-arbitrable. On the subject of fraud, respondent also states that the claimant and its principals misrepresented the value of upheld, thereby inflating, padding, double, etc. Not that complaint is there. Not after not that allegation, they assert that the basis for determining the inflated values has not been disclosed. These purportedly inflated shares were given to sellers as part of the consideration. Respondent goes on to state that put into perspective, claimant fraudulently gained access to 94% by paying only 13%. So, not this is the allegation. This whole para is the allegation. Worthless shares. Then, not para 236.
Again, the same thing.
These assertions and issues are clearly matters they had every right to raise before us, but they chose not to participate and have done their assertions verified and tested through the usual process. As a procedural matter, they ignored all procedural timetables. As a substantive matter, they have not appropriately placed the relevant evidence before the tribunal. There's simply no cogent evidence placed before the tribunal. That claimant perjured itself. Further, respondents have not submitted any witness evidence to substantiate their various allegations and veracity of alleged option agreement. Now, I was not going to place witness statements at all. I am saying decide jurisdiction. It also does not appear that the options agreements were produced before the emergency arbitrator or other fora. Now, please see this. They admit that these were not produced before anyone. I'm saying you have suppressed the agreements. They also say so. But what's the justification? It also does not appear options agreements were produced before the emergency arbitrator or other fora where the respondents objected to the tribunal jurisdiction. So he's saying when you objected to jurisdiction before the emergency arbitrator, you did not bring this. Now that's at the interim stage. This is the final stage. But double standards being applied also.
If you were to prove fraud by evidence, you would be participating and waiving
Correct.
your jurisdiction.
Absolutely.
Right.
It is only at a very late stage after testimony of the claimant's witness had been given. Not mark this, because after that, how many more testimonies came? Only at a very late stage after testimony of the claimant's witness had been given, and they refused to rule on jurisdiction by then, and instead kept taking more and more evidence by them. It is only at a very late stage after testimony of the witness had been given that respondents have attempted to produce these agreements, months after having the benefit of seeing the pleadings. This is, among other things, a patent misuse of process. Now, where is the finding that this has been suppressed? Fact is, they admit it is suppressed, but they say, look, you, the defendant, should have produced it earlier. But how do they deal with the charge of suppression? That they could have held this is not relevant, it is not material. We find no suppression. Then, 237, allegation of fraud and criminal breach of trust are not trivial matters to be lightly made and considered. They carry a high burden of proof depending on the context. Respondents have not met this burden for the purpose of establishing fraud in a civil matter. Like I said, I am not trying to establish fraud here. At the outset of the proceedings, tribunal issued a procedural calendar, directions on the parties on when to submit arguments and evidence. Claimant complied with the calendar, respondent did not. Tribunal at its direction, the claimant sent communication to respondent via mail and hard copy, invited them to participate in the proceeding, which they simply failed to do. So they agree, I have not participated. In short, respondents defaulted and failed to produce submissions or evidence despite repeated prompts. Following hearing and presentation of final respondents commence sending boxes of documents out of time, out of sequence, without providing them to the claimant. The same thing is repeated again and again, without seeking leave of the tribunal. Who says, I've showed your lordship the prayer. I showed your lordship on the last day. The last is, give us leave to file it. Because in the earlier, not finding, just give me that para. In the earlier, some earlier box was sent. So they said, look, it's been put in without seeking appropriate leave. So now, I sent it again. And I said, I'm asking for this leave. Please see that. I showed it on the last day. The last para of that. Yes, yeah. But if your lordship goes to page 54, para 120, once more, that whole letter is set out. Just the last para, just above page para 121. Grant leave to the respondents to take the material enclosed on record. Just above para 121.
Yes.
I specifically asked for leave. And leave not on what? Your lordship has seen that whole letter is set out. It included all these Nangia reports. Not Nangia, I'm sorry. Agarwal, Lodha and all of that. Alvarez, Marshall, all the data saying I'm taking the jurisdictional point again. Please decide it. I asked for leave. So I'm not to go back to this line at para 237. Following the hearing and presentation of final submission, respondents commence sending boxes of documents out of time. These documents are well not before their submissions are over, out of sequence, without providing to the claimant and without seeking leave. Tribunal did not open them and is unaware of its contents. Then, how is it noted that entire letter? That entire letter has been quoted. Accordingly, based on the evidence that has been properly placed before us, there is no evidence to discharge the respondent's burden of proof that the claimant were guilty of fraud. So, ostrich, I will not look at the box, although I have looked at it. First, I say I did not receive it. Then I say I couldn't open it. Then I say claimant did not receive it. Then I say, look, I got the box, I've got the letter, I've got everything, but I did not look at it. After I've asked them to respond. Now, my lord, if they did not look at my letter, how did they ask them to respond?
Out of the box thinking.
So
it's entirely on that. Does not decide.
they have not. While there is not sufficient evidence, etc. Then, my lord, while there is not sufficient evidence to find that drop in upheld, the share price was solely due to respondent's conduct. How is it not relevant to deciding the point of fraud? It appears to the tribunal likely that the claimant's inability to control local due to respondent's conduct and obfuscation of financial information seriously and negatively impacted fraud. It's impacted upheld's share value in myriad ways as elaborated below. They're saying this, but please remember, the Lord claimant's claim of misrepresentation leading to drop was rejected. They used this to not throw me out on jurisdiction, but the claimant's claim that I misrepresented the value of local and did not give them control leading to fall in the price of shares has been rejected in the award. Their claim of misrepresentation failed. If your lordship remembers, otherwise I'll just show your lordship the para. I'll read. In the circumstances given, the claimant has failed to satisfy its burden of proof that Dr. Avi and that Dr. Azim and Kimberlite are liable for misrepresentation. The issue of damages does not arise. The misrepresentation alleged was that. Then, my lord, para 239. In these circumstances, the tribunal is not in a position to fairly entertain fraud allegations. So we are not entertaining it, not that we are not that they are deciding it. Respondents made a deliberate decision not to participate. Respondent Group A was advised by counsel throughout the course of the proceedings. They chose a course of conduct that disrupted. Where do they get?
Same thing.
Yes, same thing. There's nothing new here. Then, Lord, jurisdiction. Lord, Mr. Mukherjee correctly points out, Lord, please see the last 3 lines of para 239. Or the last bit on the page 108 from the top of the page.
Yes.
This disturbing course of conduct, together with lack of evidence proffered for its serious allegations. So serious allegations are there. Serious allegation, not mark this, has made it impossible for the tribunal to decide these issues on merits. No one asked them to decide on merits.
Rather, you are precisely asking them not to.
Absolutely. Accordingly, and for the reasons set out above, for which the respondents have only themselves to blame, tribunal does not and cannot decide the allegations of fraud. Now, as he says, this is a giveaway sign. Records that is a serious allegation. You simply find, he should have said one line, the allegations are not serious. That would have been the end of the matter. Doesn't say that. Says we are unable to decide it. Does not and cannot.
But they rely on Avitel also.
They do. But they say we don't decide. I cannot and do not. This is the language here.
Yes.
This is ostrich. Not with respect. This is being an ostrich. Everything is before me. I have an obligation to decide jurisdiction, and I say, I cannot, I do not. Then 240 is the NCLT point, which someone else will argue. And then the prayers after that are pre-arbitration objections. I'm not dealing with that. This is all to do with the rest. This is not to do with fraud. But on fraud, that is not this. Apart from there may be one para. Give me one moment. No, this is all on NCLT thereafter. 255 onwards, I think there may be something. Yes. Now, if your lordship comes to 255, where the decision part starts.
Yes.
Now, it may not be specifically to do with fraud, I don't know, but they say this. Having considered the party submission, tribunal finds it has jurisdiction to hear the present disputes, but without deciding the issue of criminal fraud.
Mr. Bachata, you have a division bench with this.
Well, But next day, my lord, I'll finish in 45 minutes. Give me 45 minutes, I'll not take care of the legal part, my lord. And I'll not try and not put all these findings in the, not even if they don't concern me, I'll give your lordship a roadmap of the award. So it's easier for whoever comes in next. Or should, on the fraud part, my lord, I'll prepare.
If there is some coordination between you, your juniors can just try it out with Mr. Pandey also and you.
But not, I think
Not
not on facts and on the award, on fraud, my lord, I think I've dealt with it.
Yes,
sufficiently.
elaborately. So,
Your Lordship, would Mr. Bachawat be finishing on the next date?
Yes, 45
ask Mr. Bachawat that.
45 minutes.
Yeah.
45.
Hard
It's
in part
taken
for
in total 17 hearings for this.
for further hearing on April 25, 2025.
Great.
I do appear for that.
This is a contempt application. Mr.
Contempt application.
It
No,
appears
I'll just give your lordship.
already dismissed. Can appear? Canta.
Yes.
Now, I will just give your lordship a background of the matter, what has triggered this contempt application. A suit was filed. I will indicate. A suit was filed before the Learned City Civil Court at Calcutta, seeking for a declaration and injunction. An injunction was granted. What was the nature of injunction? That the defendant, number one, would not project or proclaim himself as the owner of a property, and will not create any third-party interest in respect of the suit property. The subject matter of the suit was for cancellation of a deed of conveyance, which has been executed by my own vendor in favor of my tenant, a tenant of that property. I will just take your lordship once to the plaintiff.
Sure, I'll just intervene. The first contempt application
Yes,
was filed before. No, I'll just put in a word. It was affirmed on 21st of November 2023. In that contempt application, it was a specific averment of the petitioner that they have taken out an application before the lower court to withdraw the Order 39 2A application. Lordship, as on date, let them at least inform this court what is the status of that application. Have they withdrawn it or is it still pending? From November, today is April.
First, my lord, since my learned friend has tried to prejudice your lordship, kindly come to the last annexure to my contempt application, volume 4, 741. Initially, we filed a section 10 application, my lord, alleging contempt, my lord, of an order passed by a trial court. Now, when the matter was heard, the honorable judge was of the view that since there's an order of the appeal court, your order has merged with the order of the appeal court, you have to go before the honorable appeal court. That's why we sought to withdraw.
I was present
and
there.
this is the appeal contempt matter.
I was present there. I was
Kindly
present
take
there.
up that
I was
order.
part of the order. My name appears in the order. The Honorable Justice Devanshu Boshak was not convinced that any act of contempt has been committed by us. And therefore, when it was insisted that this order has become final and it has been passed by a division bench, the Honorable Division Bench was pleased to direct that then go and file it before that court. That is the state. That is the actual state of affairs.
Kindly see that order, man. 741. On the prayer made on behalf of the petition, CPN number is dismissed as withdrawn. My lord will kindly come to the order of the learned trial. And then I will come to the lordship's order.
No, this arises from an order passed by whom originally?
Originally by the
By the
civil.
city civil court, we had what had
They preferred an appeal from that order. Your lordship declined to interfere.
right.
So that order has now merged with my lord's order.
So then you approach the trial court
Now we
with
initially
contempt.
we filed an application before the learned trial court saying that there is a disobedience of the order.
Yes.
Now thereafter we filed an thereafter it was advised that it should be withdrawn and we should go before the High Court saying that there is a contempt of the order, section 10 of the Contempt Act.
Huh. So that you withdrew ultimately.
We withdrew. With regard to the proceedings which we have filed before the learned trial court, we have also filed an application over there that we don't want to proceed with that since we are going.
So you have withdrawn before both forums.
Yes.
So then what is this? What are you hearing now?
Application has been filed, but the learned presiding judge of the city civil court was not available over there.
No, that's not a.
No, we don't understand, Mr.
So that has also been withdrawn, man. Madam, we kindly come to page 45 of my application.
If both have been withdrawn, then what are we hearing then?
No, this, madam, kindly come to the page 45 once. After hearing, judge in charge has been pleased to dismiss as withdrawn the said application.
So then you have withdrawn before both forums.
Yes.
Then what are we hearing now?
This is a contempt of the order of the appeal court.
The order passed by.
Kindly come, give me some moment, madam, I will clarify.
You say ad interim was granted by the trial court.
Trial.
Appeal was dismissed.
Appeal was, they preferred an appeal.
Against that. You got the injunction, they preferred appeal, that appeal was dismissed. So affirming that order.
Kindly, I will just take your lordship to those orders once.
So what did you withdraw before Justice Bossak's division bench then?
That's a section 10 application. Contempt against an order passed by an inferior.
Section 10 CPC.
Section 10 of the Contempt Act. Contempt.
Oh, right.
Contempt of an order passed
So
by.
this is an independent contempt application before this court?
Yes, absolutely. Kindly come.
Yes, Mr. What do you say to that? They have shown an order whereby they have withdrawn from that court. So on that, we are only on that.
Yes.
On merits, we'll hear you after him.
Lordship, when the matter was taken up for hearing, Honorable Justice Boshak was not convinced.
No, that is not recorded in the order. We won't go into that.
Yes.
As of today, they have withdrawn the application before the trial court, and they have also withdrawn the other application. So we can hear it.
Yes. Lordship, yes.
Kindly come to volume 1 of.
You have copies of these directions? Because without direction, you cannot get copies.
So first, whether a rule will be issued.
Prima facie, whether make out a prima facie case of contempt, we'll direct you to serve copy. That is the practice we follow. We give a copy, and if they fail to satisfy us on their affidavits or otherwise, then we issue a rule and they have to give a show cause and could not have been served before we directed. Contempt cannot be served. What is the contempt, act of contempt? Tell us that. Yes.
Kindly come to.
We'll fix a date for hearing on that and.
Kindly come to the first order, madam. I will take your lordship to the chronology of orders, madam.
No, just tell us, Mr. Dotto,
Yes,
verbally, what is the contempt? So the injunction was that they cannot transfer in favor of third parties?
And most importantly, they cannot proclaim or project themselves as owners of the property till the disposal of the suit.
On the basis of that deed?
That impugn deed.
Right.
Now, what they are doing,
Yes.
they are projecting and proclaiming themselves at various places as they are the owners of the property.
Anything in writing by them?
Yes, absolutely.
Show us something for prima facie case. Then we'll direct you to stop a copy.
First annexure. That's 137. They have filed a application before this High Court in another eviction suit which is pending before the Kolkata against the Kolkata police, saying that we are the purchasers of the property. We are now have become owners. Kindly 137.
Yes, 144 para 2, they say transferred absolutely.
Yes.
This was filed after that order.
Yes, absolutely. The order of the trial court is on the 24th of February 2023. Your lordship have dismissed the appeal on the 9th of December 2024. And they have affirmed this application on 13th of December 2024. Served me on the 16th of December 2024.
And just show us that order of the trial court, which is now under contempt.
That's order of contempt. The trial court order is at page 128 and my lord's order starts from 131. (128), my lord.
Yes, yes, yes. Yes, prior facie we find, Mr. Basu, that there is some. So we'll direct him to serve copy unless we find that we can't.
Yes,
direct him.
that's not that for service of affidavit.
How soon can you use your affidavit in opposition? Just for our satisfaction that there is no contempt on the face of it. 10 days.
10 days.
You will take a week for reply?
1 week, sufficient. Because we are suffering. Will not.
Yes. Being prima facie satisfied that a case of contempt has been made out, comma, we direct the appellant to direct the petitioner to serve a copy on the alleged contemners, indicating that the matter on the alleged contemners, comma, who are represented by counsel in court today as well. First of next para, affidavit in opposition, affidavit within bracket S, because if there are several contemners, each of you have to, you know the affidavits, the affidavits in opposition, if any, shall be filed by April 25, 2025. Reply, if any, shall be filed by May 2, 2025. But in any event, the next Friday is a holiday. The matter shall be, the contempt application shall next be listed for hearing. 16th Friday, hearing on May 16, 2025. দুটোর সময় রেখে দেবো নাকি যদি শুনতে হয় তাহলে তো কি করবো আপনার কি ডিভিশন বেঞ্চ আসছে হবে আপনার meeting? না না তুষার সাহেবের কাছে তো আপনাকে নিতে নাকি রিটার্নেবল আফটার শ্যাল বি লিস্টেড আমি তো যখন কিছু করতে শুক্রবার আমি নিজে বসি জাস্টিস প্রসিডের সময় তো আপনি বসেন difficulties other division bench judges shall be listed on a pre-appointed date thereafter. Pre-appointed means we'll publish it in the list sufficiently in advance. The returnable date.
That's
So that it will appear in the list carrying the date.
only one thing, my lord. Since your lordships are satisfied there is a prima facie case of contempt,
Yes.
that there is some interim protection, that there is no further acts of contempt. My lord can see the
That won't
full
help.
volume.
It's like, I mean,
How many acts of contempt have been done? Now, in this 1.5 months,
cannot do that, Mr. Dotto. You know that. And that won't help also. Because if they are in contempt of a particular order, what is the use of multiplying that? That order is already there. If they're in contempt, they'll be punished. In contempt, we are not hearing it on merits.
now because my
Convince Mr. Upadhyay. That's your duty.
now the problem is
We are not hearing the injunction application or the suit on merits. We
Absolutely,
cannot grant an injunction. That will not be in aid of the contempt application.
my lord,
That colonies. কি ব্যাপার ছিল? তাহলে এখন কি করতে হবে? তাহলে এটা কি হবে?
তাহলে এটা হবে চতুর্থ ফর এন্ড আদার্স সিন্স বিজনেস স্টেট আছে হয়ে গেছে এটা
এটা তো সবাই এটা এখনো হয়। Deceased bracket closed, being represented by his legal heirs and representatives Srimati Shamsundar Shaw and others. Push up, however, comma, Can 1 of 2009 within bracket old Can 1267 of 2009 bracket closed, comma, which was the application for substitution of the heirs and legal representatives of opposite party number Chaturbhuj Shaw has not yet been allowed. Full stop. As such, comma, the cause title in the aforesaid two orders be deemed to stand corrected and be read as Srimati Shakuntala Shaw and others versus Chaturbhuj Shaw and others. Full stop. This order be deemed to be a part of the orders dated March 21, 2025 and February 14, 2025. Full stop. Let the matter be listed before the appropriate bench having determination, comma, subject to being mentioned by the parties. Dr.
Started I appear for the petition abroad.
Yes.
Last petition on 7th of March 2025, my lord has been pleased to issue a rule.
The contemners are present in court. The order as to us is complied to the fullest extent.
You are responding contemner
1 and 3. Contemner numbers 1 and 3 have filed two separate affidavits. The relevant affidavit is of container number 1. My lord, kindly takes page 34 of the thicker one. Has your lordship got it?
Yes.
This is the entire chart for the following pages. The first date being January 57. This is the starting of the service period of the employer. His salary has been calculated. Now, this is notional because we only have a skeleton record. Nothing more. We have considered the very basic for the first day. We have given the all increments which he was due as per law, giving all promotional benefits for the basics. We have calculated up to his date of actual retirement when he was forced to retire. Then we have calculated up to the date when he was supposed to retire as on the considering the date of superannuation. Thereafter, we have given interest on that period as also on the period from the date of his superannuation date till present at the rate of 8%.
What was the original direction by this court?
All retirable benefits. Apart from this GPF part, everything was paid prior to the issuance of rule.
Now you have made this calculation. Who is to pay?
Well, it has been paid.
Oh, this has been paid.
This has been paid.
Very
This is the only calculation.
What do you say?
So far the payment is concerned, my lord, the certain amount has been sent to my client.
The actual payment is at page 51.
This is extras here. And my lord, this is the GPF amount.
So what has not been paid now?
Everything has been.
Everything has been paid now.
Everything, but not the TDS.
Yes.
The deduction, TDS deduction, that has been kept open in the
For filing of return. Let him finish.
Contempt application.
We have
whether they are entitled to deduct TDS. Why aren't they? There was a direction of court to pay that amount, but in law they are entitled to deduct that, and you will get benefit of that if they give you the
we
TDS
have said
certificate.
in the affidavit.
I have prayed for that benefit has not been extended to me. That is why, my lord, I have
That benefit has to be extended to you by the tax authorities.
tax authorities. I have applied, but they have rejected.
That's a different cause of action altogether. So we'll dispose of the contempt application by saying that the order has been complied with. We'll record your submission that TDS benefit you have not got. So we'll keep that open for you to take out an challenge against the what you
Even in the affidavit, we have indicated that with regard to the TDS, we have paid and we have given the certificate.
Yes.
And we have said that it is upon the tax authorities and him to file the return and get the benefit.
The present contempt
Two
application.
separate affidavits by 1 and 3.
But the breakup which has been
Yes, I'll hand over.
my client,
I'll
that
hand over.
breakup is
I'll hand over this affidavit, entire affidavit.
Affidavit, you have not got a copy?
No.
Man, I have just affirmed today in the morning.
So then you go through this.
My lord.
My lord,
You come back.
The affidavits in opposition or compliance?
compliance.
Opposition. It was actually.
No, my lord,
Very well. The affidavits filed on behalf of the container number 1 and container number 3, in the nature of affidavits in compliance, filed today be kept on record. Full of copies thereof are handed over here and now to the learned advocate for the petitioner. Full of next para. In order to enable the petitioner to apprise itself of the contents of the affidavits, the matter is adjourned till April 25, 2025, when it will be listed under the same heading.
The personal appearance.
Personal appearance of the alleged containers is dispensed with for the present.
দুটো দিলাম না?
Mr. Dotto, they are personally present.
Yes, yes.
তাহলে প্রথম লাইনে একটা করে দেবেন যে the alleged containers are personally present in court as per previous direction. লাস্টে যেটা বললাম যে dispense with for the thank you.
Number 3.
Yes.
That I am for the petitioner.
Right.
My lord, an appeal against the decree is pending. My lord will remember.
This CO is an assigned matter to me. Assigned. Yes.
So, my lord, not separately assigned, my lord. When the
Yes. Therefore, it's assigned. It has been assigned.
Yes.
What decree has been challenged?
My lord, I am the decree holder.
Yes.
A decree of mean profits had been passed in my favor. My lord, I had put the decree into execution. However, my lord, the execution has been stayed.
So, my lord, being aggrieved by that, I am before your lordship. In the meantime, my lord, an appeal has been preferred by my learned friend as far as the main decree is concerned. Now, my lord, that is pending. Your lordship will, your lordship has in fact recorded that fact in your lordship's last order and had adjourned the.
What is the stage of that appeal? That appeal is before this court only, another bench.
My lord, the appeal is before Justice Mantha's bench.
Ah.
So, my lord, that is
Adjourned till
fixed.
22nd April already they have handed over the.
Oh, my lord, that has been adjourned till 22nd of April.
Still have to keep it after that.
Yes.
We'll give 1 more week so that
Yes.
the server copy of an order dated April 7, 2025, passed in FMET 566 of 2023, comma, arising out of the. This is arising out of what? FMET? Why FMET?
My lord, FMAT is the first appeal that they have filed. My lord,
That's a miscellaneous appeal. There cannot be if FAT it has to be then if it's against the decree.
my lord,
What
it
is this
not
appeal
yet-
against?
Not admitted yet.
Degree and order, but already it has been filed before the trial court, district judge. Then
Why FMAT? FAT it should be. Was there an order 21 rule 9701 application or something like that? Why FMAT? Which arises. How can it arise from the? Have you got a copy of that memo? FMAT. How can there be an FMAT against the main degree? Which arises out of Nakore, which is submitted by learned counsel to arise out of the parent decree in connection which the execution case within bracket from which the present revision arises, bracket close, has been taken out. Full stop, next para. The said order indicates that the appeal has been fixed next on April 22, 2025, full stop. Accordingly, comma, in order to enable the parties to have an adjudication in the said appeal, comma, let the matter stand adjourned till, let the present matter stand adjourned till April 25, May 2, 2025. Second. You also please check if you have a copy of that memo. You must be having.
Yes, my lord, we are contesting it over there.
Check up how can it be FMAT?
Yes, yes, my lord. I'm so grateful.
Thank you.
Yes, Your Lordship, for the petitioner, on last occasion, I have seeken.
I appear on behalf of the opposite party, Milord.
Your
Today at 12 noon, Milord, I have been served with a copy of the revisional application.
Your Lordship, amicable settlement talk was going on last occasion. I have
Failed, now
submitted,
failed.
and even on last day, the compromise talk was going on. So it was
This
not.
arises from what? What sort of a suit?
Section 24
Section
application.
24 application order. Lordship, till yet it is not yet decided that whether.
Let
there
us
is-
send you to mediation then. Why keep it pending before
I
this?
have no instruction regarding any settlement going on now.
Then we'll take up the matter for hearing.
Lord,
I
Lord,
have
can you
the-
Lord adjourn it for a week?
Learned
Milord?
counsel for the petitioner submits, comma, in consonance with the submission made on March 7, 2025, comma, when the matter was last taken up for hearing, comma, the talks of settlement are going on between the parties. Full stop, next para. However, comma, learned counsel for the opposite party submits that a copy of the revisional application has been served on him only today, and he is not instructed about any talks of settlement going on. Full stop. In any event, comma, to enable learned counsel for the opposite party to take instruction on such count, comma, let the matter stand adjourned and be listed next on April 25, 2025 under the same heading. Please come back. If there's no settlement, I'll
Your
let it
Lordship,
be
on-
understood. I'll take it up for hearing.
Yes, Your Lordship. On lower court, 6th of May matter is fixed for evidence. If Your Lordship kindly take it after 6th May. Kindly.
Why? No, no.
Kindly, Your Lordship.
You're the husband?
Yes, Your Lordship.
No, definitely not. This is against alimony. You cannot stall indefinitely.
Number 5.
My lord, I appeal for the alleged contempt, my lord.
Yes.
My lord, I must indicate, my lord, a direction was given for filing affidavit, my lord. That affidavit direction has been complied with, admittedly by me, my lord, belatedly. I have served, my lord, of the affidavit on him yesterday, my lord. I am carrying, my lord, a physical copy, my lord, with. May I
Physical, you file it. We'll give you time for
my lord, we
reply.
have served it upon the other side. as well.
Affidavit in opposition filed today. Affidavit on filed on behalf of the alleged contemner today be kept on record. Full stop. The delay in affirming the same is condoned and the same is accepted. Full stop. Time for filing reply thereto is extended till April 22, 2025, full stop. An advance copy of the same shall be served on the learned advocate for the petitioner. Full stop. The matter shall next be listed on April 25, 2025.
Great.
But it's already been submitted. I've made over a copy.
Yes, no difficulty.
And my lord, on my instruction only, my lord, there's no rule has been issued, nothing, my lord. I have asked the concerned contemptor to be present.
Need not be present.
Very well.
Unless we direct him to be present, need not be present.
Very well. Only a clarification, my lord. Grateful.
Number 6.
Yes.
But I beg to appear for the contempt lordship.
Yes.
But
Petitioner is not there, so you are saved.
no, we are always safe, lordship.
You have complied with the order or what?
Not yet over phone because today
Have you got a copy of this application?
Not yet, lordship.
Not yet.
But
What
even
is-
then, my lord, I intimated, I take to information, my lord, there.
None appears to move the application. Full stop. Let the matter stand adjourned till adjourned for the day. Adjourned for the day means Friday week. The next Friday is a holiday. We are not directing service because I am not prima facie satisfied of the contempt.
Lordship.
If you are in contempt, Mr. Naik, you know what to do. You take care that
But I have because
You-
my lord
you-
was pleased to observe that civil suits are there. Lot of observations have been made.
because the order you know what order was.
Ultimately, lordship's desire was the line may be given and that will not create any.
So you take instructions on that also. You are getting 2 weeks time. So if you can comply, if you have not complied, comply, then come back. It will be better.
Lordship. That
Next.
instruction I have already. I have requested my.
Thank you. Next.
Grateful, lordship.
7.
Lordship, I am for the respondent. Lordship,
Yes.
I'm for the
division bench has modified the order and said the in place the cool lordship returned the money with 8%.
Return the money.
Whatever he deposited 99 returned.
What was the direction of this court?
The lordship directed to
the contempt petition
Well,
has become infructuous because they have appealed
Modified.
Yes, they have appealed before the division bench, and they have further.
You are the petitioner in the contempt application.
Yes. I'm led by Mr.
You are the petitioner.
Yes.
Very well. Learned counsel for the parties hand over a server copy of an order dated of a judgment and order dated March 24, 2025, passed in MAT 1904 of 2024 with MAT 57 of 2025. Full stop. By virtue of the said order, said judgment, comma, it is submitted by learned counsel for the parties that the division bench has been pleased to modify the parent order of this court. Full stop. Accordingly, CPA 905 of 2024 has been rendered infructuous and is accordingly dismissed as infructuous. No arrest to cost.
I'm ready.
Thank you.
Number 8.
Yes.
Item number 8, I am for the petitioner.
What is the contempt? Alleged contempt?
My lord, the alleged contemptor is my lord District Magistrate Purbo Medinipur.
What is the nature of contempt?
Nature of contempt, my lord? The District Magistrate was directed to determine the quantum of compensation because the petitioner's land was encroached in the Garbo, my lord, that in the extension of a high tension electricity line. So my lord was pleased to direct upon the contemptor to decide the quantum of compensation.
Has not done it.
Within 3 months, my lord.
Has not done it.
Has not done it, my lord. Only one part of the order that the district magistrate could have approached the BL and LRO or directed the BL and LRO of that particular jurisdiction to get a report, and he has done that. That BLRO has submitted a report.
He has not yet decided.
No, my lord, not at all decided.
You have instruction to appear. You cannot have instruction to appear for the.
I cannot
the-
place unless
the
your
district.
lordship ask me. Because
District magistrate, we cannot ask you.
District magistrate authority.
If you want, we can implead you as a contemptor. Then
May I leave the court file then?
so very well. This is appearing for the first time. The contempt.
Yes, my lord, first time.
A prima facie case of contempt has been made out inasmuch as the alleged contemptor has apparently not complied with the order of this court dated December 19, 2022, passed in WPA 27761 of 2022, comma, inter alia directing the alleged contemptor to decide the amount of compensation, quantum of compensation payable to the petitioner. Learned counsel for the petitioner submits that although in part compliance, comma, the alleged contemptor has taken a report from the concerned BL and LRO, comma, no adjudication has been made within the time as stipulated in the same said order, that is within 3 months from the date of approach being made to the alleged contemptor. full stop, hence, the petitioner shall serve a copy of the contempt application on the alleged contender, indicating that the same shall be listed for hearing on May 2, 2025, when an affidavit of service to that effect shall be filed by the petitioner.
Grateful to your lordship.
You are not required to appear in the matter.
No need. For out of person, I have.
Understood. Yes.
Item number 9.
Yes, you are for the obviously the contempt.
Contender number 2, my lord, I have received the instruction, although no copy has been received.
They are not moving
But
the
I
application.
have received instruction that my connection has been provided.
Has been provided.
My if your lordship, my lord, kindly give me 5 minutes time, or I can hand over that copy which has been received by me just 5 minutes.
Mr. Mukherjee, do that by way of an affidavit. I'll record your submission that it has been completed. None appears to move the contempt application at the time of call. Full stop. Learned counsel appearing for the alleged
number 2.
Alleged contender number 2 submits that in the meantime, the order of this court, the parent order of this court has been complied with by giving electricity connection to the petitioner. Pushed up on the prayer of the learned advocate for the petitioner for the alleged contender number 2, the said alleged contender is granted leave to file a short affidavit, containing the necessary averments and annexing relevant document, if any, to substantiate such claim on the returnable date. Pushed up. A copy of the contempt application shall be served on the alleged contenders at the earliest, and an affidavit of service to that effect shall be filed on the returnable date. Full stop. The affidavit sought to be filed by the alleged contender number 2 shall be filed also on the next returnable date with an advance copy to the learned advocate for the petitioner. The matter shall next be listed on May 2, 2025. Next.
Lord, I am for the petitioner. Affidavit of service.
I'm
for respondent, lordship.
Contempt application upon the contender number 2, can it be served upon me by the petitioner advocate?
যেখানটা আগের ম্যাটারটা বললাম না, অনেক কপি অফ দি কন্টেম্প্ট অ্যাপ্লিকেশন শ্যাল বি সার্ভড অন দি অ্যালিস্ট কন্টেম্নার্স, ওইখানটা হবে কপি অফ দি কন্টেম্প্ট অ্যাপ্লিকেশন শ্যাল বি সার্ভড on the contender number 1 directly and on the alleged contender number 2 through the learned advocate appearing today for the alleged contender number 2, and the rest follows. So good service affected.
They are appearing, madam.
Oh, you're
now they have today just now, my lord, hand me over a copy of a email which is, my lord, sent to them, my lord, by the SBI cards, stating that they are apologizing.
Apologizing will comply with the order, lordship.
We'll give you 2 weeks for that. Thank you. You are for there is only one contender.
4 contempt.
All you are appearing for all 4. Very well. Learned counsel.
Lordship, one indulgence. Can you give us 3 weeks because the vacation is there in this?
What vacation? No vacation.
Next week is not a vacation.
Not a vacation, but
Next week we are giving you very well. We'll give them 3 weeks. What is the difficulty?
We'll comply with that.
Affidavit of service filed to be kept on record. Full stop. A printout of an email purportedly written by the written on behalf of the alleged contenders to their learned advocate, who is appearing in court today, is handed over in court and kept on record, which indicates that the alleged contenders are agreeable to comply with the order of this court and tender unconditional apology, citing CITING oversight on their part not to comply with the order of this court. Full stop. The alleged contenders seek 3 weeks time to so comply. Full stop. Accordingly, on the prayer of the alleged contenders, let the matter stand over till May 2, 2025, when the alleged contenders shall file an affidavit of compliance to that effect.
Only one thing, lordship. It has been forwarded to the petitioner also, to Ashok Mitra, GM.
Acha, very well, no difficulty. You are citing it, so it's.
My lord, it seems so.
আচ্ছা তাহলে তুমি একটা জিনিস করে দাও, লার্নেড প্রথমে যেখানে বললাম প্রথম সেন্টেন্সে the learned advocate appearing for the alleged contenders
আমি জানি না, মানে I have no knowledge of
address to বললাম কি hands over an email
client is here, মানে
to the learned advocate and to the petitioner.
Monkey tank. Thank you. Thank you.
I'm waiting for the alleged contempt.
Order has been complied with.
Why did you comply with? We don't have business.
My lord,
We have so little business and you're complying and we're not.
my lord, the dormant freeze was removed last Friday when I had committed myself. My lord, but what they had suppressed that there was a freeze by RBI
Oh.
because they had done cryptocurrency trading in huge volume, which was nowhere mentioned in the contempt application. My lord, we had to pursue with the RBI from Monday morning onwards, and which was removed on Wednesday morning, my lord. And the petitioner is doing.
RBI has to take appropriate steps for that. Before freezing the account, they have to be given a notice at least. Since you have been able to convince the RBI on the other aspect, please convince them on that also.
Right.
Please, they are free to go ahead with this. Their procedure against them if they are illegally trading with cryptocurrency or whatever. Give a notice, do that.
Man.
Without a notice, everything will be set aside by any court of law. Learned counsel appearing for both the parties submit that the parent order of this court has been complied with. Full stop accordingly. CPAN 1524 of 2024 is disposed of as infructuous. No address to cost. Thank you. Give your names, both of you, please. Yes. 12.
Your Lordship, I beg to appear for the petitioner, Your Lordship. The alleged contempt has been served in both the matters. 12 and 13 were taken analogously.
13.
And
they have received.
They have received, Your Lordship. As well as there was an indication where it has been mentioned that this is the date, returnable date, and the order was also submitted along with that.
What was the nature of the complaint?
The complaint was, Your Lordship, there was a complaint regarding before the Bar Council of India, which was ultimately forwarded to the Bar Council of West Bengal regarding certain activities of the private respondent, which were in conflict with his advocacy. And that was not disposed of. And that was why the writ application was filed before this honorable court, and it was disposed, both the writ application were disposed of, wherein the private respondents were separate in both the writ petitions, wherein it was mentioned, Your Lordship, by wide order dated 15th May, that in view of the innocuous nature of
contempt is the president of the Bar Council.
Your Lordship, the chairman of the bar.
You have described as president.
Lordship, that leave may be granted for that purpose, so that it can be changed. Lordship. The Bar Council was the authority whom it was directed. So that's why we have to mention one name, who is the head of that.
If he chooses not to appear, we will issue a rule. Let him come personally. On the prayer of learned counsel for the petitioner, leave is granted to the learned advocate in the court for the petitioner to carry out the necessary correction to the cause title of the contempt application insofar as the designation of the alleged contemptor is concerned. Pushed up, in both the matters. From the affidavits of service filed today, I find that the alleged contemptor has been served appropriately. Push up, however, despite such service, the alleged contemptor chooses not to appear before this court. Push up, since this court has already observed in its previous order dated March 21, 2025, that the alleged contemptor has not decided the complaints lodged by the petitioner despite the direction of this court dated May 15, 2024. Parent order is the date is the same in both. May 15, 2024, a rule of contempt to issue calling upon the alleged contemptor to show cause as to why penal action shall not be taken against him in terms of the prayers made in the contempt application. Push up, the rule shall be made returnable on May 16, 2025 at 2 p.m.
Much obliged, Your Lordship. Indeed.
Yes.
So before coming to the contempt application, I have filed an application for appropriate order, CAN 1. This application I have filed because due to miscommunication between the client and learned advocate, I could not disclose the fact that the alleged contemptor has preferred an appeal. That fact, Lordship, I could not disclose. So I have.
Have you given a copy of this to him?
Yes, I have given a.
No.
Served
Not given.
No. Now, this fact I lordship praying for to
Incorporate in the-
incorporating the fact that
Very good.
but
Yes, sir.
subsequent development is
No, the appeal was
the appeal
disposed
has
by
been
the court.
dismissed.
Disposed and dismissed. ma'am.
What was the nature of the direction of this court?
Lordship, kindly the from refunding amount which has been deducted from out of the pension amount of the petitioner. Lordship, kindly come page 24.
Oh, pension was. So you have to comply now.
My lord, I'm praying for 3 weeks time.
Why
to come.
3 weeks?
My lord, next week, 2 days, my lord, there. And my lord, the contender is the respondent, contender 3 is the contender. They are naming same person, they are named.
All
one
bank
person.
responsible.
Kindly look
You are appearing for all the contenders.
But they are same name twice.
Oh.
Respondent 2 and respondent 3, same name twice. My lord.
You know that you are that person. So
Three, only 3, my lord. 3, one is not
Technically,
technical. No, I am not objecting, my lord. We are complying with lordship, but it is only for the 3, my lord.
22nd.
you have no scope of objecting unless you prefer an SLP.
No, that is
Can one of 2020 can one to appear kochili aji?
Yes, yes.
Thank you. Can one of 2025 is an application seeking appropriate order which of learned counsel for the petitioner submits in support of the said application that in the original contempt application, the fact that an appeal had been preferred against the parent order, in respect of which contempt has been alleged, had been omitted to be disclosed in the disclosed due to bona fide inadvertence of the petitioner. Full stop. It is submitted that that by way of this application, such incorporation is prayed for. Full stop. Accordingly, can one of 2025 is allowed, thereby deeming it to be incorporated in the original contempt application that an appeal had been preferred against the parent order. Full stop. That apart, learned counsel for the however, learned counsel for the petitioners hands over the server copy of judgment and order.
7th of April, my lord.
Thank you. Order is not yes, and judgment and order dated April 7, 2025, passed in FMA 837 of 2024, whereby the concerned division bench has dismissed the appeal preferred by the alleged contemners and has affirmed the parent order of this court. Full stop. In view of the same, learned counsel for the alleged contemners seeks 3 weeks time to comply with the parent order of this court, as affirmed by the appellate court. Full stop. Next para. Learned counsel appearing for the alleged contemners further submits that the alleged contender number 2 has been mentioned twice as alleged contender number 2 and 3. Full stop. Be that as it may, the said misjoinder does not vitiate the filing of the contempt application. Full stop. In any event, in view of the submission of the alleged contemners, alleged contender number 3, time is granted to the said alleged contender to comply with the direction of this court within 3 weeks. Let the contempt application be listed on May 16, 2025, when an affidavit of compliance shall be filed by the alleged contender / contemners with an advance copy to the learned advocate for the petition.
Affidavit service kept to that.
That I've said probably. Na hole prothom line e dite affidavit service file. Thank you. Yes.
My lord, I am for the appellant, my lord. My lord.
This is appearing for the first time.
Yes, my lord, my lord.
That same
my lord. Correction.
mistake.
Correction. Yes, my lord. Kindly correction of the cause title, my lord.
Learned counsel for the petitioner submits that due to certain errors in the cause title of the contempt application, leave be granted to carry out the necessary corrections to the same. Full stop. Such leave is granted. Full stop. The learned advocate on record for the petitioner shall carry out the necessary corrections to the cause title of the contempt application during the course of the day.
Yes, my lord.
Full stop. What was the nature of the contempt?
Nature.
You are a cultivator.
Yes, my lord. I am a agriculturist.
So what was not done? What contempt? What is the act of contempt?
Non-payment of the premium by the bank authority, my lord.
Since a prima facie case of contempt has been made out, inasmuch as the alleged contemners have not complied with the order of this court by making the requisite payments to the petitioner, the petitioner shall serve copies. There will be 2 contemners now.
Yes, my lord.
Copies on the contemner and the added contemner, indicating that the application shall next be listed for hearing on May 2, 2025, when an affidavit of service to that effect shall be filed by the petitioner.
Item 16, same, my lord.
16. Call করুন একবার. Same order.
Yes, sir.
15, 16, same order, আলাদা করে. Yes, Mr. Mukherjee, you are appearing it.
For the contemner, my lord.
Yes.
Lordship's order at relevant pages 24.
24.
The WPA is disposed of granting leave to the petitioner to apply the electric connection proper format before the WPA SCDCL upon such application being.
You said that now suite is not necessary.
No, not necessary.
Yes, Mr. Mukherjee, what do you say? Why didn't you complain?
Though we are late, my lord, kindly come to paragraph 9 at page 24. There was a direction that in the event the petitioner complied with all the formalities.
They have not.
We have given a letter. It is a late letter, but it is not techno-commercially feasible, my lord. That is the reason, my lord, we cannot. This has been sent on 7th. Instead of 40,000, now it will be 75,000. I have taken instruction. And as per my
You have got a copy of this.
His client probably has not served him. He has
You-
received on 9th. My lord can keep it any day next week or after 20th. My lord, he can take instruction and come.
No, you just file an affidavit indicating this.
I'll do that.
এটা ফেরত দিয়ে দিন একটু. Learned counsel for the alleged contemner submits that although belatedly, the alleged contemners have communicated in writing to the petitioners that the electricity connection being given to the petitioners is not feasible techno-commercially. Push up next para. The alleged contemners shall file affidavits in opposition disclosing the relevant fact and annexing the relevant documents in that regard within a fortnight from date, with an advance copy to the learned advocate for the petitioner. Full-stop. The reply, if any, shall be filed within a week thereafter.
Instead of a fortnight, can it be 3 weeks?
Why 3 weeks? You have got that copy.
I have, my
You
lord.
do it within a day. 2 weeks, Mr. Mukherjee. Already you are late in communicating.
Till next week, my lord, all holidays are there.
2 weeks we are giving you.
As you know.
You draft it tonight. Have your client affirm it on the next week after next.
My lord directs I can, but today is Friday evening.
So what? The matters shall next be listed on May 16, 2025
I'll do it, ma'am.
for hearing.
I'll do it. I'm grateful.
You're getting the entire next week after the week after the next.
I'll do it. I'm grateful.
Thank you. 18 with 90, yes. Yes.
The challenge has been thrown. My lord, this is with regard to the formation of an association of a premier housing complex in Calcutta. It's naming Greenfield City, my lord, comprising of about 4,000 flats. Now, my lord, what has happened here is this, my lord, the petitioners are all the owners, all the
for the
owners of their
respondent.
respective flats in the said project.
Private.
Now, my lord,
Yes.
said project.
Respondent number? Very well.
Now, my lord, they were desirous of forming an association in respect of their structure, which has been shown by the Greenfield City builder as an elite structure comprising of 14th floor. There are two types of structures in the said complex. One is of G+4 that has been termed as classic, and another is G+12 that has been classified as elite. Now, my lord, as because the law permits for formation of separate association even in a housing complex, my lord, in order to collect the consent from all the respective owners of the elite structures, my lord, they initiated a process.
Elite, that will be called an elite society.
No, it's not. They have termed, builders have termed it as elite. We never.
The society has to be named as elite society by nomenclature. One is a classic society and another
One is of
very good.
G+4, my lord, and this is G+11 and 12.
So
my
what
lord,
has elite done now?
Now, I am coming to that, my lord. They wanted to form a separate association of their own.
You are classic.
No. We are the owners are the
You are
representing
elite.
Elites.
And they are the classics.
No, they are the builders.
They
They are the builders. Now, my lord, the collection of consents is required because for the purpose of formation of an association, my lord, two things are required. First is to collect the majority consent of that particular phase, and second is submission of forme, which is another vital most aspect. My lord, in the process of doing that, my lord, all on a sudden it came to their knowledge that already another parallel process has been started and it has culminated in the process
by other members of the elite itself.
Other members of the elites, my lord, I will not say that because builders, along with few members, not the entire members, keeping rest of the members in
that exercise has been started.
That exercise has been started and has been completed. Has been completed by acceptance of forme. Now, after getting that information, my lord, we made an immediately objection to the competent authority. The person who has been entrusted under the statute to give affirmation of the forme. Now, my lord, thereafter, my lord, on the prior to that, my lord, we have already filed this writ application challenging the illegal acceptance of forme. That is 8125, which is appearing. During the pendency of the writ application, my lord, the appropriate authority, that is the competent authority, give us a.
Ma'am, you are appearing for the competent authority. For competent authority. That is the no. That is not the competent authority.
Well, competent authority.
As per them, you are the incompetent authority. Yes.
Well, they gave us a notice of hearing, my lord. We took part in the hearing.
Though competent authority have served because they are necessary.
Everybody has been served. In fact, they have appeared also. In the previous state have appeared.
Competent authority was
True state has appeared.
True state, yes.
A true state has appeared, but I don't know whether they are right now here or not.
Mr. Kormokar won't be the competent authority.
No, he is the builder.
Does it look very competent?
Now, my lord, thereafter, my lord.
So, what is your grievance in the writ petition?
The grievance is this, my lord.
Yes.
The procedures which are prescribed under the statute for the purpose of acceptance of forme and subsequent formation of an association has been completely given a go by.
Why no notice was given?
My lord, may I say one thing, my lord? Lordship, there are two aspects here. My lord, if someone has to form an association, my lord, the first step which needs to be undertaken is to intimate all the members of the said society that we are intending to submit the property under the fold of the West Bengal Apartment Ownership Act. So a notice has to be issued by the majority members to the rest of the members that please please see that we are going to submit it. If you kindly give your consent.
Here no notice was given.
Well, the notice has been issued. What the act says, that notice can be issued by a single person or by a majority or by all the own. But here the notice has been issued by 5 members, countersigned by the builder, who is not the owner, whose name is not appearing in the notice as a declarant. That invalid notice was also not served upon the rest of the members. Now, my lord, thereafter what has happened, the law says that there has to be a declaration. That declaration has to be submitted before the competent authority. Now, the competent authority, my lord, on the basis of such declaration which will be submitted.
Second 210A or something.
Yes. Lordship vividly remembers that. Lordship's order and judgment is I have brought, my lord, squarely covered by Lordship's order. Now, on the basis of that, the declaration has to be submitted, annexing the relevant documents containing the form E notice, then the completion certificates, then the building sanction plan, the consent of the members, all have to be annexed along with the declaration, which has to be signed and verified by each and member of the said society personally before a magistrate. Now, my lord, on the basis of submission of such declaration, my lord, before the competent authority will issue notice to the parties concerned that, and further will hold an inquiry and will see whether the property comes within the fold of the act or not, and examine it. And thereafter, if it finds that all the paraphernalia have been met, then there will be a reasoning. After reasoning, he can reject the acceptance or can allow the acceptance. In case of allowing the acceptance, he has to serve he has to return the declaration to all the members. And if it is rejected, then my lord, remedy lies before the statutory authority by way of filing an appeal. Here, my lord, from the very inception of issuance of for me, and then an most unfortunate incident has happened. Instead of submitting a declaration, my lord, the competent authority has acted on the basis of an application filed by an anonymous person who is not the owner. Now, acting on the basis of this application, a notice was issued.
Who is that anonymous person? The developer,
my lord.
not developer.
No, not this. His name is not reflecting in for me notice.
No, then no appeal is available against this.
Now, my lord, thereafter, in the said notice, my lord, it will reveal that notice has been issued to that applicant, neither to the declarants. Law statute says notice has to be issued to the declarants and to the parties concerned. But here, the name of the person who has submitted the application and in whose favor the notice was issued, his name is not appearing. Neither the name of the declarants are appearing. Now, my lord, on the basis of that, my lord, on a very particular day, that on 12th of April 2022, Form A was submitted.
So you are seeking a setting aside of that Form A acceptance?
Yes.
Who are they?
They are the builders.
What is their role?
They have no role. As per the statute, they have nothing to do.
So why have you implemented them? They were also declarants.
Because they have signed upon
as declarants.
me.
They are the only ones who have signed.
No,
those four other
another 5 persons,
right?
But not the majority persons. The law is very clear in this. Either it has to be signed by a single person, or it has to be signed by a majority persons, or by all.
As the case may be. As the case may be.
As a case. Now, my lord, competent authority on the very day when the Form A was submitted, verified it without holding any inquiry, without considering any objection, because he has not served notice to anybody, so no one will come to object that.
Right.
And accepted the Form A without any reason.
Yes.
So the entire process has been.
Reason is probably not necessary. A reasoned order is necessary under the statute.
Has to be there as per section 10A.
All right.
Now, my lord, without wasting your lordship further time, my lord, may I just come to the, lordship, kindly come to the reply to the 8125. Kindly come to page 8, reply to the 8125.
Yes. Which page?
Page 103A.
Under 3A, yes.
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 My lord, let's say this is the Form E notice, but prior to that, my lord, I will to act itself so that lordship can seize what is the actual statutory provision with regard to issuance of Form E. Lordship, kindly come to West Bengal
Yes.
West Bengal Apartment Ownership Rules 1974.
Yes.
Lordship, kindly come to clause 3(1)(a).
Apartment Ownership Act. Thank you. ঠিক আছে.
My lord, in case where the majority of the owners rules, my lord.
Yes. In case where the
majority of the owners intend to submit declaration under section 2 in Form A, they shall give notice of their such intention to all the remaining owners in Form E. Now, my lord, kindly see the notice which is at 103A. That we are the owners of the apartment number such and such, situated within the property aforesaid. We intend to submit our property to the provision of West Bengal Apartment Ownership Act. We have information that you are also an apartment owner within the said property. And in view of the above, we are requested to furnish the particular of the apartment as required in Form A, and you are further requested to execute the Form A when the same will be prepared. Now, my lord, it has been signed by 4 individuals. 5 individuals. Kindly see. Counter signed by the Greenfield City LLP, which I can demonstrate from the writ petition that they are the builder and they are not the owner. And in fact, the Rajiv Kumar Agarwal, who is countersigning in the capacity of Greenfield City LLP.
Rajan.
Rajiv. Actually, it's Rajiv Kumar Agarwal.
He signs as Rajiv.
He is not a declarant. His name is not appearing in the body of the notice.
No.
Now, my lord, kindly see who is Greenfield City LLP. That will be from the deed of conveyance, which I have annexed to the writ application, page 18 of the writ application. Be more precise, my lord, page 19.
19.
The 8125 WPA number, page 19.
Yes, 19. Greenfield Builders.
Greenfield City LLP Limited Liability Party duly registered under such as having its registered office at such and such, jointly referred to as the builders. Now, my lord, kindly see.
They are a confirming party in this.
Yes, they are the promoters also, but promoter is not signing here. Here the builder is signing. And as per the definition of the owner, my lord, kindly see the definition of the owner is at section 3IA.
Yes.
As you kindly see the owner, definition of owner.
I'm
from
there.
The act.
Yes.
In relation to any property or part thereof or apartment includes any person owning such property or part thereof or apartment, any person deemed to be owning such property or part thereof, any promoter, a lessee of such property or part thereof or apartment where the lease is for a period of 30 years or more, provided that any person who has executed an agreement for purchase or for taking lease for a period of 30 years or more of any property or part thereof or apartment or has been in consideration or part thereof shall be deemed to be owning such property or part thereof of apartment, even though the document for purchase or lease of such property or part thereof apartment has not been registered. So,
Here, you admit that they are the promoter, although
no, they are the developers. They are the builders. They are not coming under the definition of owner.
Very well. They are not the promoters.
No, they are not the promoter. They are the builders.
Very
They
well.
themselves is described as
in the agreement. Yes, sadly it says builder.
Builders. Now, my lord,
builder, yes, yes.
kindly see this notice.
Promoter has been defined here. Let us see.
Yes.
What is the definition of promoter?
In the deed, promoter is.
Promoter means a promoter is defined in some other act, which we don't have. Read it out for us, Mr. Parma. I'm afraid of what messages may come. Maybe the Prime Minister is giving a message or the Chief Minister. So you read out better from your phone.
Promoter means a person who constructs or causes to be constructed a building on a plot of land for the purpose of transfer of such building by sale, gift or otherwise to any other person or to a company, cooperative society or association.
So that's why he has had that page open. Covers a builder.
My lord, kindly see Bengal Greenfield Housing Development Company Limited.
Covers a builder, the definition of promoter in the other act.
Here, West Bengal Housing Board is the promoter.
Where do we get that?
From page 18.
But builder is included within the definition of promoter as per the act. Maybe they are describing it as promoter, but
Here,
builder
my lord,
comes in.
Kindly see in the deed itself, page 18.
Even if in the deed someone else is described as the promoter, definition of promoter in this act includes a builder, person who builds for the purpose of developing and handing over.
Even if that be so, my lord.
So builder is included, yes.
For the time being.
But builder is not named as an as a declarant. That point remains.
Yes, that point remains. And
they sign, but whether they have...
and this particular notice, my lord, has been signed by 5 persons. It has not been issued by the majority.
Yes.
It has not been issued.
What is the total number approximately?
Above 3,500.
3,500 above. All right.
And for me, the provision says that it has to be issued by the majority to the rest of the members. But here, it is issued by 5 persons. Now, these 5 persons, my lord, apart from that.
Why do you say it's an application by a stranger?
That I'm coming to that. First, this is a for me notice, which they say has been served upon all, but we say that it has not been served because they have to append the receipts of for me in the declaration itself. Now, my lord, on the basis of this, now thereafter, my lord, kindly come to the notice part, which is at page 95.
On the last occasion, you took 4 or 5 points. I'm just mentioning. One is that majority have not given.
Yes.
The other is that stranger application by stranger.
Yes.
The third is that something affidavit by builder same day acceptance.
Acceptance by same day.
And rule 2A 3 years limitation. You have
Yes,
taken a
3 years
point.
limitation is there.
And you have also taken a point that some of the declarants or some regarding some of them there are ongoing constructions probably.
Yes, ongoing
not yet
construction,
constructed.
property cannot be submitted. Entire property cannot be submitted.
And last is that no receipts, as you say, no receipts as per Form A.
Then Lordship, my lord, kindly come to page 80 for once.
80.
80. This is the order passed by the competent authority. Lordship, kindly come to page 84.
Right.
Why I say there is no provision of online application. Well, kindly see page 84, facts with respect in the instant case under this heading.
That is in 83 in my copy. This is probably, I'm looking at the reply, sorry.
From the reply answer.
Oh, reply. Reply of 8125.
8125.
Anyway, the pagination is 83 here. Facts with respect.
Yes. Online application for formation of association. It is what the competent authority is saying. Online application for formation of association with respect to Greenfield City was made on 29th of March 2022. On 9th of April 2022, competent authority issued notice to the declarants under clause A of subsection 10A under the Act to attend the hearing.
That is being done repeatedly to the declarants themselves.
No, my lord.
Notice, but it has been interpreted, probably you have interpreted that it is not only the declarants but also the others.
No, my lord, may I say this? My lord, what the Act
Language is-
says?
Yes, yes. Act
Kindly
is-
come to the relevant provision.
Persons concerned or something like that.
Section 10A.
Yes, yes.
Why I say there is no provision of filing any application. Section 10A, it says, my lord has found a declaration or an instrument to be submitted before the competent authority and to be dealt with by him. Any declaration referred to in section 2 or any amendment thereto or any instrument referred to in subsection 3 or subsection 4 shall in the first instance, my lord, kindly mark this, shall in the first instance be submitted by the sole owner or all the owners or the majority of the owners of the apartments in duplicate within 30 days from the date of its execution to the competent authority along with the copy of site plans, building plans and the notice of intention to submit the property to the provision of this Act by the majority of owners specified in section 2 to the remaining owners of the property in such form as may be prescribed when such declaration is made by the majority owners. The remaining owners shall be allowed to submit declaration subsequently, either individually or collectively in such form as may be prescribed. Now, on receipt of declaration or an amendment thereto or an instrument referred to in subsection 1, the competent authority shall, after issuing notice to the parties concerned.
Yes, parties concerned was initially being interpreted as the declarants themselves.
They have not issued this notice to the declarant also.
Yes,
The notice
that's an
has been
additional.
issued to the applicant informing him to come up with 2 declarants.
You've got a copy of that notice also?
Yes.
Very good. So let us proceed with this page.
Yes,
83.
after issuing notice, my lord, kindly see what are the procedures which requires. He has to inquire, examine, hold inquiry. Then a reasoned order has to be passed before acceptance. No reasoned order here, no inquiry here. Same day submitted, same day accepted. Now, my lord, kindly come to that notice. Page 95. So, my lord, I have my respectful submission is this: there is no provision of filing any application. It has to be a declaration at the first instance, as per section 10A. But kindly see the notice which has been issued on the basis of that application. They say that notice has been issued as per section 10A. If that be so, then there has to be a declaration first, which we submitted before the authority. Then this notice should be issued, not before submission of the declaration. The my lord, kindly see, notice is hereby given to under the clause A of subsection 2 of section 10A under the West Bengal Apartment Ownership Act 1972 to the applicant to appear before the undersigned on 12th of April 2022 at 4:30 p.m. along with two declarants of Form A, two apartment owners who made declaration in Form A, and the attorney. I am putting this question to myself, my lord, from where they are getting two declarants or 4 declarants or 6 declarants. How he come to know when a notice is being issued only to the applicant? He should not be knowing how many declarants are coming. The applicant shall bring duly affirmed Form A along with the relevant documents. The applicant, the 2 declarants, and the attorney shall bring original voter or PAN card for identification along with a photocopy of the same. The declarant shall submit a confirmation or otherwise letter to the undersigned during the course of hearing. The format of such letter is enclosed herewith. Please bring the printout of this format also. The applicant shall bring a printout of the online application made in the district. The application may be rejected if the applicant either fails to appear before the undersigned on that day. Well, kindly see, my lord, it has no official memorandum number. It can't be understood whether this particular notice is for the Greenfield City apartment, Greenfield City residential owners or not. And only this notice has been issued to the applicant, not to the declarants, because declaration was not made. First, the declaration has to be made.
Yes, understood.
Now, my lord, kindly come to Form A, acceptance of Form A, which is at page 109. Now, this is how it was accepted. Kindly see, no reasoned order. The statute said there has to be an order in writing given reasons.
Yes.
Therefore, then accept or reject the declaration.
Right.
No reason, only an affixation. Now, my lord, kindly see.
This is the declaration.
This is the declaration over which they have affixed that yes.
Order is the other one you are placing. Order has to contain reasons.
There, that was.
This is the declaration.
This is the declaration.
Yes.
My respectful submission is this: before such acceptance is being made by the authority, there has to be a reason why I am accepting this.
Yes, no reason in that order.
No
You are
reasoning.
placing that order.
That came afterward. Only upon my objection to the Form A hearing was called.
Oh, this is a hearing on your objection post facto.
Yes.
After it has
yes.
been.
That is what I am saying, my lord. It was accepted on 12th of April 2022.
Where is the acceptance? There is no acceptance as such. No order as such.
Affixation, my lord. Kindly see. Only the accepted by competent authority. No reasoning. That is when it came to our knowledge, we made a comprehensive representation objecting it, acknowledging that they issued a notice of hearing to us. Then the hearing took place. Then this order came. Now, my lord, why I say, my lord, I will be saying there is a collusion between the builders and the competent authority. My lord, kindly come to page 89 of the builders' affidavit which they have filed before the competent authority. Page 89.
Yes.
Kindly see paragraph 6. I say that as long back as 12th April 2022, a declaration as contemplated under section 10, read with section 10A of the West Bengal Apartment Ownership Act 1972, was submitted before the competent authority, on receipt whereof an order was passed on 12th of April 2022 accepting such declaration. I say that such order of accepting the declaration passed by the competent authority is statutorily immune from any challenge, and on such score alone, the said complaint deserved to be dismissed in limine. Same day declaration submitted, same day it was accepted. all the provisions of section 10A has given a go by. Now, my lord, I say in the affidavit in reply that the submission of the entire property is time barred. Lordship is well aware of this fact that section 2A, Rule 2 of the West Bengal Apartment Ownership Rules, period of submission of Form A prescribes a time limit.
Yes.
That time limit is, as you kindly see, Rule 2A, period of for submission of Form A.
Yes.
The sole owner or all the owners or majority of the owners of every property shall.
Years from completion certificates.
I have appended some of the completion certificate, occupational certificate, because it comes under the municipality. So there will be an occupational certificates. It's all a time barred. Now, they have annexed one, they have said in the acceptance of Form A that they have appended all the completion certificates. But my respectful submission will be, as it is coming under the municipality, it has to be occupational certificates, but not the completion certificates. Because Lordship is well aware that section Rule 34 of the West Bengal West Bengal municipal rules, it says that occupational certificate has to be issued. First, a builder has to be intimate the municipality that we have completed a building. Now there will be an inspection by the officials. After that inspection is being done, that within 15 days, an occupational certificate has to be issued. Now, my lord, they have stated,
yes,
in the acceptance of Form A that completion certificates have been issued, has been submitted. My respectful submission, my lord, had that been properly examined, Form A wouldn't have been accepted. And now a completely different affidavit has been filed by them, saying that only upon completion of the entire project, completion certificate will be issued. Then if that be so, it is there, they have stated in their affidavit, supplementary affidavit.
No, the rules say that completion certificate has also to be submitted.
As per the West Bengal Municipal Act, my lord, in the building rules, first the builder has to write a letter to the municipality along with a certificate which is called the completion certificate.
No, does this Apartment Ownership Act contemplate completion certificate also to be filed along with that?
Yes.
What does it do so?
Yes, that is in the Form A.
Form A itself.
Form A, the declaration form.
Right.
Well, kindly see what are the requirements.
Yes.
Yes.
Copy of relevant completion certificate.
Yes. It's there. Copies of relevant completion certificate, then copies of voter card, PAN card of declarants, copies of the receipt of the letter in Form E. These are all the criteria. They have stated in the Form A that completion certificates have been annexed. Kindly see Form A once. They have stated that completion certificate. Kindly see Form A, page 109 for once. Yes. The relevant, page 110, the copy of the relevant completion certificate is also appended herewith and marked as annexes. Now, in the reply, just now they have stated here, in the supplementary affidavit which they have filed previous hearing, they have stated in page 2, paragraph 3, that I say, my lord has found
opposition
in the supplementary affidavit. It is their supplementary affidavit, my lord. 214265.
Could be there somewhere. Yes.
May I read, my lord?
Page 2.
Page 2.
Para 3.
Yes. Inconsistent statements have been made.
How?
Well, they kindly see, my lord, what they have written is not matching with their averments and their content. I say that the subject project is spread about 45.69 acres of land. The entire project is to be completed phase-wise. There are 3 categories of buildings being LIG, MIG, HIG. The LIG is entirely separate category, whereas MIG and HIG share common areas and amenities, and as such are intermingled and inseparable in all aspects. The construction commenced on and from 2010. Phase-wise, the construction is being carried out inside the phase block-wise construction.
This one of 4 is the housing board.
Each block consists of a building. Upon completion of each building, the municipal authorities are issuing occupation certificates so as to enable transfer of the flats without keeping the same pending for the completion of the entire project. The completion certificate shall be obtained only after completion of the entire project. They ought not to have, they could not have submitted the Form A, but they have stated that they have annexed completion certificates. And now here they are saying that completion certificate for the entire project is awaiting, my lord.
But then that limitation does not apply.
I say, my lord, completion certificate usually do not applies here. Here only the occupational certificates. Completion certificate in respect of those housing complexes which comes under the Kolkata Municipal Corporation.
The housing complex was not complete when the application declaration was.
Few
not
yet completed. Only
so either of the two. Either there was no completion certificate, they could not apply at all. Or if occupation certificate is to be taken as completion certificate, time.
Respondent 4 is a builder.
Builder. Okay.
And under construction property has also been submitted.
So that is all.
No, my lord. The another important aspect is this. My lord, they say in the previous occasion.
Yes, we have some time, some more time to pass.
I will take 2 minutes, my lord.
ED matter is released. Must be ED. Other matters are released.
I will say only 2 things, my lord, here. That they have stated on the previous occasion that they have relied upon power of attorney. Now, my lord, my respectful submission is there is no provision of power of attorney. At least a substitute signature was not allowed, and that is not the legislative intent. All the owners have to come forward and to execute and to sign and verify and affirm before a magistrate. Now, my lord, kindly see, for the ones I will only take your lordship to the relevant provisions. Kindly see section 2A first. They have stated in the previous occasion that they have used power of attorney to take my consent. Kindly see this act, my lord, section 2, application of the act.
Yes.
This act shall apply to every property having residential units or both residential and commercial units, and the sole owner or all the owners or majority of the owners of every such property shall submit the same within such period as may prescribe to the provision of this act by duly executing and registering a declaration setting out the particulars referred to in section 10.
What is the bar of a power of attorney?
But there is a bar.
Where?
Well, kindly come to Rule 3 of the West Bengal Apartment Ownership Rules 1974.
Rule 3, yes.
Yes. The declaration under section, my lord has found?
Yes, yes.
The declaration under section 2 by the sole owner or all the owners or majority of the owners, as the case may be, of a property shall be executed in Form A, be signed, verified by the sole owner or majority of the owners, as the case may be, in presence of the magistrate or any other person competent to administer oath. Now there is a penal provision also, if I do not sign it on my own. Kindly see section 16 of the West Bengal Apartment Ownership Act 1972. If the owner of any apartment subject to the provision of this act contravenes any of the provision of section 2, section 7 or section 8, by any bylaw that may be framed by the competent authority, any covenant, condition, or restriction set forth in the declaration to which he is subject to a party, or if such owner stands in the way of submitting the property to the provision of this act and does not furnish the particulars or documents as required for execution of declaration in accordance with the provision of section 10A and the rules made under this act, he shall, at the instance of the manager or the board of managers on behalf of the association of the apartment owners and aggrieved apartment owner, or in proper case the competent authority, on conviction before a magistrate, be liable to a fine which may extend to ₹1,000 or to a term of imprisonment which may extend to 6 months. So I have to go there and I have to sign myself. My power of attorney cannot be used in substituting my consent for me and for me. And nowhere in the acceptance of Form A they have submitted any power of attorney. It is only the competent authority who has said that power of attorney has been used. Neither by the builders. Builders have not stated that power of attorney has been used. It cannot be used. There is an express bar. And moreover, the competent authority was more eager to get the property under the fold of the act. And Lordship, lastly, there is a judgment of your Lordship's order covering the entire aspects of this matter. I need not look anything beyond that. Lordship, Form A is vitiated by non-compliance of the statutory rules, and consequently, the formation of association is not only time-barred but also illegal. There has to be a valid acceptance of Form A before formation of an association. If the acceptance is vitiated by non-compliance, then Lordship has held that association is also bad and illegal and cannot act.
Give a copy, it's an unreported. Any particular paragraph? No.
All entire facts are same, on similar footing. Not a single action of the competent authority, my lord, is as per the law. Not a single sentence, my lord, confirms the statutory requirements.
Very well. You can start for 2 minutes, yes.
Milord, there is a guideline, Milord, issued in 2021, Milord, by the Housing Board, saying, Milord, in what manner these forms are to be submitted. Milord, my learned friend, Milord, is vociferous that, Milord, constituted attorney, Milord, cannot do this. They have to, Milord, personally do this. Milord, that is
Can the Housing Board guideline override the law?
the law.
Law requires the person to go and sign
Law
before a
will
magistrate.
not give us. Milord, a constituted
No,
attorney
Mr. Banerjee,
Yes,
suppose I have to furnish before any authority,
Yes.
passport authority or whatever authority, if I have to furnish a declaration signed before the magistrate, can I do it by power of attorney?
Milord, that's all through
Because if there was no, as Mr. Roy rightly pointed out,
Yes.
if there was no provision mandating it to be signed before a magistrate, I could have understood. That owner has to submit, that's sufficient, he could do it. So, but he has to sign before a magistrate. There is a sanctity
Signing
attached
before
to
a
it.
magistrate is, Milord,
Who will sign before the magistrate? The power of attorney, the
I'm saying
constituted.
something on oath. Milord, that is, Milord, the idea.
Yes.
That, Milord, that is why, Milord, I'm
Then
required to
in
go
this case, the power of attorney, the constituted attorney will go and sign before the magistrate.
Milord, yes, if no. My lords also accept, Milord, petitions, Milord, which are affirmed, Milord, by the constituted
Yes,
attorney.
yes, but there is no requirement in our acceptance, in our rules, that it has to be affirmed before a magistrate.
Here also, Milord, subject to my limit.
Commissioner on oath has to affirm it, and we accept only on that.
So, Milord,
And even if it can be done by notary,
Milord, I
that
can-
is also in our rules. We are bound by our rules.
So, Milord, I can take oath on behalf of Mr. Kormokar and say something on behalf of Mr. Kormokar on oath. Milord, if I
Saying something before a court of law and because we are not governed by any statute. Even, I mean, for the ends of justice, we can do certain things.
registering authority, Milord, I
226
can
we can
convey.
226 we can sue to issue a rule
That's true.
on
Milord,
an affidavit, one page affidavit by anybody.
True.
So that is not the power exercisable by a competent authority.
Milord, before a registering authority, a constituted attorney, Milord, can deal with a property belonging to someone on the basis of a power. Milord,
Is there a mandate that it has to be signed by a magistrate before a registering authority?
No.
Thus, an application is contemplated.
Here
That is
also-
what I'm saying. If an application was contemplated, declaration only, then I can understand.
Wait, I call.
Not
Wait.
if you come prepared on this. We'll start.
Right.
Heard in part. Heard learned counsel appearing for the petitioners.
My lord,
Full
on-
stop.
Sorry, my lord, only one thing, my lord, you kindly keep in mind. My lord, we will definitely argue on that. My lord, it was them, my lord, who had, my lord, given power to us.
We have not given any power to anyone.
We'll look into that.
My lord, I'm filing my reply, my lord. Over there, they are supplementary affidavit, which they have.
আচ্ছা প্রথমে লেখো reply to the affidavit reply to the supplementary affidavit file to be kept on record for sub heard in part for further hearing on April 25 2025 next returnable date next Friday next available Friday
Wait.